All right, I'm going to go ahead and call the Legislative Post-Audit Committee meeting to order. We've got a quorum because we have Mike Peterson online. Thank you, everybody, for coming today. I do want to remind the members of the committee, and the members of the audience, if you're going to be testifying, we've got a very long meeting today. We've got a lot of stuff on the agenda. So I apologize in advance. I will cut some people short, in the interest of time if we're falling too far behind. So please limit your comments to questions that help us better understand what's going on rather than statements. I do want to remind everyone that the meeting is being live streamed. Members, we need to remember to turn on and use our mics during the meeting. And if you haven't got your travel voucher in, get it to me or get it to Chris so we can get those processed. The first item on the agenda that I want to do is I want to recognize our staff. They recently won the National Legislative Program Evaluation Society Impact Award for their at-risk audit. And I want to thank all of you for your hard work. We have several members of the staff team that were here. We have Matt. Matt, stand up so they can, or wave your hand, And then Heidi, back there. And then Kate. Where's Kate at? Anyway, thanks for your work. And I did just a little bit of, I shouldn't say research too much, but, we really do have a great legislative post-audit team here at the state. And, I just looked at it real quickly, and since 2022, they've won 5 national awards. So thank you for your work. And Chris, thank you for your leadership and work with the committee. All right. So we'll get into the meat of the agenda today. And the first thing we have is by one of our award winners. We've got Heidi presenting to us on the free lunch counts. Heidi.
Now I'm on. All right. So good morning, committee, on this very rainy Monday morning. So I'm going to present the free lunch audit. I know you have probably a huge stack of audits in front of you. So you're looking for the one that starts with reviewing free lunch. This audit was conducted by Cade Graber, Sam Dadds, Megan Bishop, and Matt was the manager. The audit has one question. It's on page 2. So it's, does the number of free lunch students used for at-risk funding accurately reflect the number of students who are eligible for the program? I'm going to give you a short answer to that question, and then I'm going to give you a very long answer to that question. But the short answer is that the number of free lunch students used for determining at-risk funding appears to be significantly more than the number of students who may be eligible for the free lunch program. Okay. So I'm going to start with just a little bit of background, which is on page 3. So the National School Lunch Program is a federal program that reimburses school districts for meals they serve to students. The United States Department of Agriculture administers the program. The USDA reimburses participating schools for each lunch that they serve. In exchange, schools must offer free and reduced price lunches to students who qualify, and they must serve meals that meet federal nutrition standards as well. So in the 24 school year, all 286 school districts in Kansas participated in the National School Lunch Program. The program requires districts to offer free and reduced price lunches to qualifying students, and students can receive a free lunch if they meet one of several criteria. So if the student participates in certain federal programs, that includes programs like TANF, SNAP, certain Medicaid benefits. If the student is a migrant, runaway, in foster care, or experiencing homelessness, all of those students also qualify for free lunch. If the student attends a school that participates in the community eligibility provision of the National School Lunch Program, those students are eligible. And I will talk a little more about what the community eligibility provision is here in a moment. And then if the student's parent or their guardian submits an application that reports total household income is at or less than 130% of the federal poverty line for the size of the household, then those students are eligible as well. In 2024, the income threshold was $39,000 for a household of 4. So students can receive a reduced price lunch if the student's total household income is between 130% and 185% of the federal poverty line. So in Kansas, the free lunch count is connected to at-risk funding. So in Kansas, the state provides at-risk funding to school districts. The funding is largely allocated based on the number of students in the district who are eligible for a free lunch. So state law and Department of Education rules require that students who are eligible for a free lunch also meet some additional criteria to be counted in the at-risk funding count, and that criteria is listed at the top of page 5. So in 2024, districts received about $2,500 for every student who met that criteria, and in that year, the state paid about $563 million to districts in at-risk funding and high-density at-risk funding. So next, I'm going to go through the various processes by which students qualify for free lunch. I'm on the bottom of page 5. So students who meet certain criteria are automatically eligible to receive a free lunch. So generally, these students are not required to submit a national school lunch application to receive that benefit. Instead, state agencies and school districts use a process called direct certification to determine which students are automatically eligible to receive a free lunch. In Kansas, several groups are directly certified through kind of multiple processes. The Department for Children and Families, DCF, compiles a list of students who receive federal benefits, including SNAP, TANF, and Medicaid, as well as students who are in foster care. So DCF reports those students in a system that KSDE operates, and then school districts can access that system and see which students should automatically receive a free lunch. So with the exception of students in foster care, if at least one student in the household is on that list, then free lunch is extended to all of the students in that household. Additionally, school district officials verify that other groups of students are automatically eligible. This includes students who are experiencing homelessness, runaways, and migrant students. So if the district determines the student meets the criteria for one of those designations, then that student is also automatically eligible to receive a free lunch. Students who meet these criteria can receive free lunches for the whole year, plus 30 food operating days into the next school year. So students who are directly certified for free lunch are counted in the at-risk funding count. Students who are on the 30-day carryover period on September 20th are also counted in the at-risk count, even if they don't qualify after that period. The percentage of free lunch students who are directly certified has increased substantially, from 46% in the 21 school year to nearly 80% in the 24 school year. For students who are not directly certified, a parent or guardian can submit a national school lunch application to the school to determine eligibility for a free lunch. The appendix on page 25 shows an example of what that application looks like. The school district officials use the household income information on that application to determine whether the student may receive a free lunch. And USDA rules require the district to consider only the information on that application when making the determination. In the 24 school year, an estimated 16% of students who qualified for a free lunch did so by submitting an application. And there's one additional way to qualify for a free lunch. The community eligibility provision allows eligible schools to provide free lunches to all enrolled students. But to be eligible for community eligibility, the school must have at least 25% of its students eligible for free lunches through direct certification in the prior school year. The schools that participate in community eligibility provide all of their students with a free lunch, and this includes students who otherwise would not qualify. And students are not required to submit an application to receive that benefit. KSDE, though, asks students who attend community-eligible schools but who are not directly certified to complete a household economic survey to determine at-risk funding counts. This is because the department only counts students who have household income at 130% or less of the federal poverty line in the at-risk funding count. The department uses the household economic survey to identify which students meet that criteria. So the appendix on page 27 shows an example of the household economic survey. Now this group is much smaller. Only about 4% of free lunch qualified students submitted a household economic survey. So next, I'm going to talk about the verification work that we did. It starts on page 8. We reviewed information for 769 randomly selected students who qualified for a free lunch in the 24 school year. The students in our sample were a mix of students whose household provided a National School Lunch Program application or a household economic survey, and students who were directly certified. And we requested documentation for each student from the student's school district. The random sample of students included 122 students across 55 districts who qualified for a free lunch because they submitted an application. This sample is large enough to be statistically valid for projecting the results. We used information from that application to find income tax information for that household from the Kansas Department of Revenue. When we could not find income tax information, we looked for quarterly wage information from the Kansas Department of Labor. And we reviewed the income information we could find and determined if the household met the free lunch income requirements for their household size. We reviewed 122 applications, but we could not find any income information for 14 applicants. In some cases, the application did not provide enough information for us to locate those individuals in Department of Revenue or the Department of Labor system. So for example, the applicant didn't provide a Social Security number. In other cases, we had enough information, but we still could not find the individuals at Revenue or Labor. This could be because the individual did not submit a tax return or had employers that did not properly submit wage information. The figure on page 11 shows the results of the income verification work for the 108 individuals we could find. So as you can see in that figure, 68 applications did not appear to meet the income eligibility for free lunches. So this means the financial information we could find exceeded the income threshold for the size of the applicant's household. 45 of those ineligible applicants had incomes that were at least 50% over the threshold. For about half of them, they had incomes greater than $100,000 in the year their student received free lunches. 2 applicants had incomes greater than $200,000. We projected the results from this sample to the whole population of students who qualified for a free lunch by submitting an application. Based on that, we estimate that between 54% to 72% of all applicants were likely ineligible for a free lunch. That's about 18,000 to 25,000 students. This work represents a 95% confidence interval. So that means that there is a 95% likelihood that the true ineligibility percentage for all applications is within that range. Now, there are some really important caveats on this work. So first of all, the application is a snapshot in time, while income tax returns and wage information include earnings for the whole year. So this means it is possible that a student was eligible for a free lunch at the time that they submitted the application, even if the household's total income for the year exceeded the threshold. We also could not verify the size of the applicant's household. As a result, we relied on the applicant to accurately list all household members. But if they did not, it could cause a couple of problems. First, we could have understated the amount of household income, which means we could have determined that a student was eligible even though they were not. And then second, we could have applied the wrong income threshold to determine eligibility. So our estimate only applies to students who were qualified by income, which again is only about 16% of the free lunch population. Out of our random sample of students, 32 submitted a household economic survey in the 24 school year, and we tried to verify these in the same way that we verify the National School Lunch Program applications. However, again, we were only able to verify half of the surveys. For 16 of the 32 surveys, we could not find any tax or wage information at Revenue or Labor. But of the 16 surveys we could find, 9 did not appear eligible for free lunch. So keep in mind, though, that these students who attend community eligible schools will receive a free lunch no matter what. So when we say that they're not eligible, what we mean is that they're not eligible by income, which means they wouldn't be eligible to be counted in the at-risk funding count. Unfortunately, we could not.
Could you say that again? I was spacing off and.
No problem. So keep in mind, these students who attend community eligible schools will receive a free lunch no matter what. So when we say that they are not eligible, what we mean is they are not eligible by income, which means they would not be eligible to be counted in the free lunch count, or in the at-risk count. We could not find income information for enough of the students who submitted a household economic survey to project the results to the whole population. Nevertheless, these results do raise some real concerns. For students who were directly certified, we could not verify whether they were accurately determined to be eligible. These students do not submit an application, so they do not provide any income information to the district. Instead, eligibility for most of those students is determined by information they provide to DCF or KDHE when they apply for benefits such as SNAP or Medicaid. So due to time and data constraints, we could not determine whether those agencies accurately assess eligibility for programs like TANF, SNAP, and Medicaid. Further, some directly certified students are determined by their school district, and we could not evaluate whether all the districts made these determinations correctly. So what this means is that the high percentage of automatically eligible students, remember it's about 80%, that means the overall accuracy of the free lunch count is very difficult to assess. This is because decision-making related to free lunch eligibility is dispersed among multiple state agencies and 286 school districts. So ultimately, much of the accuracy of the free lunch count, and in turn the at-risk funding count, depends on whether state agencies and school districts accurately approve individuals for their respective programs. The other analysis we did evaluating the free lunch count included looking at the number of students who could be eligible for a free lunch, but they didn't apply. So we reviewed data from the U.S. Census Bureau's American Community Survey, and we used data from that survey to estimate the number of Kansas public school students whose incomes were 130% or less of the federal poverty line. Again, that 130%, that is the cutoff for free lunch. So we then backed out certain populations of students that we know did apply. Based on that, we estimated that up to 3,200 students who were likely eligible for a free lunch did not submit an application or a survey for one. So even though about 3,200 students may have been eligible but didn't apply, remember that we found many more students who qualified but likely were not eligible. So what this all means is that in the 24 school year, the state may have overpaid in at-risk funding. So after accounting for the 3,200 students who may have been eligible but didn't apply, the state likely overpaid by about $38 million to $53 million in the 24 school year. We also looked at the districts and KSDE's verification efforts to try to understand why we saw the eligibility problems that we encountered. And we did find a few issues. And I'm on page 16. So school districts and KSDE are very limited in their ability to verify the accuracy of DCF's direct certification list. So DCF compiles a list of students who should be directly certified because they receive SNAP, TANF, Medicaid, or they're in foster care. So KSD officials told us they do not have the necessary information to verify that DCF compiled that list accurately. Additionally, there is nothing that the school districts can do to ensure that DCF compiled that list accurately. Federal rules significantly limit school districts' abilities to verify household income for students applying through a national school lunch application. So per federal rule, when a family submits an application, school district officials must make an initial determination of eligibility based solely on the information provided on that application. Generally, federal rules require districts to verify eligibility for only a very small percentage of the total approved outcomes. So the district must verify either 3% of applications or 3,000 applications, whichever is less. District officials review supporting documentation, so for example, like a pay stub, to verify a family's reported income. District staff review that documentation and determine if the student is still eligible. However, districts do not have any way of verifying this information outside of the documentation that the applicant provided. Additionally, although KSDE auditors do review several aspects of the National School Lunch application, they also cannot independently verify the household income parents report because there is no system in place that would allow KSD auditors to take that step. Districts and KSD auditors also review household economic surveys, but again, they cannot independently verify the reported income. So to wrap up here, I've given you a lot of information, but here's a few really important takeaways from this audit. So first, much of the accuracy of the free lunch count is based on whether agencies such as KDHE and DCF accurately make eligibility decisions. If there is fraud or other errors in determining eligibility in those agencies, it is likely to have an impact on free lunch eligibility. Second, household income on the National School Lunch Program application is self-reported, and generally, USDA does not permit the districts to verify more than 3% of the applications. So further, KSDE also has no way to independently verify the income information on those applications. So programs that operate almost entirely on self-reported income with very few verification efforts are inherently at high risk for fraud, waste, and abuse. And then last, most of those risks are related to the rules that the federal government has created for the National School Lunch Program. So KSDE and the school districts have little ability to correct the problems that create the highest risk for this program. We did make one recommendation. It's on the bottom of page 21. A recommendation is that the legislature should consider how at-risk funding should be allocated, including whether it should continue to be allocated based on the free lunch count. And the reason we made this recommendation is because the free lunch was originally used as a funding basis for at-risk because the number of students in poverty and the number of students at risk of academic failure in a school district tended to be similar. But over time, the program has changed significantly, which allows more students to qualify for free lunch without ever submitting household income information. So we found that a significant number of students receiving free lunch had household incomes that well exceeded the poverty threshold. Consequently, the free lunch count might not be an accurate measure of the number of students in poverty in Kansas school districts anymore. Additionally, districts now consider many more factors than just poverty when determining when students need at-risk services. So as a result, the free lunch count may no longer be an accurate measure for determining the number of students at risk of academic failure in a school district. That concludes my presentation, and I'd be happy to stand for any questions.
Do we have any questions for Heidi? Senator Tyson?
Thank you, Mr. Chairman. Not a question. I just want to thank you. I know you guys submit reports often for rewards. This one, you guys originated it, recommended it, and you've done a great job, as always. And thank you, Mr. Chairman.
Senator Petty?
Thanks. I just wanted to go back to, on your recommendation about this no longer being an accurate count for at-risk. And when you talked about the income level, just as a reminder, you did say that you were only looking at like 16% of the students that actually receive free lunch. Is that correct?
We looked at all of them, but we could only do verification work for 16%. So when we talk about that projected number, that 54 to 72% of students who are likely ineligible for free lunch, that only applies to the students who submitted an application. So for the students who submitted a household economic survey, we couldn't find enough of them in the system to project anything. And then for the direct certification students, which is the overwhelming majority, 80% of students are direct cert, their eligibility is based on whether or not DCF and KDHE are getting the eligibility for programs like TANF and SNAP and Medicaid accurate.
So the direct certification that's just tied to SNAP and TANF, it's
Medicaid.
And Medicaid, right. So, so basically you're bringing into question whether they're doing their applications correctly?
We're saying we do not know. This audit, looking at multiple other agencies and big programs like SNAP and TANF, which, by the way, we are getting ready to work on SNAP and TANF, but those are significant programs, big agencies who have their own processes, and it was just out of the scope for this audit. So what we're saying is, we don't know. So for 80% of the students who received free lunch in 2024, we don't know if they were approved accurately or not.
And under, Mr. Chairman, under that direct certification, that qualifies a whole school of students, correct?
Students who, it only applies, direct certification applies to students and then potentially the siblings in their household. Community eligibility applies to the whole school. So if a school district participates in the community eligibility provision, and there's only about 150 schools in the state of Kansas that participates in community eligibility, then in that case, that means that at least 25% of the kids in that school were direct certified. And then community eligibility means that every kid in that school gets a free lunch, no matter what their income actually was. And that is a program, that is a provision set up by the USDA. That's not a Kansas-specific thing. That is how the program is set up by USDA.
Right, and those 150 school districts, we have our highest low-income populations as well.
It's not 150 school districts. It is only
I think that's what you
150 schools.
Oh, sorry, I thought you said school districts.
150 schools in the state of Kansas participate. But yes, some of those schools are in districts with very high free lunch counts. For example, Topeka.
Kansas City.
Yeah.
And so every member in that school, regardless of their income, is eligible for at-risk funding?
Every student in that school is eligible to receive a free lunch.
And then they're counted, though, in the at-risk funding?
They're counted in the
Calculation.
at-risk funding count if A, they're directly certified, or if they're not directly certified, that's where they have to submit that household economic survey. And when they submit that survey, if the income they report is 130% or less of the free lunch count, then yes, they are counted in the at-risk funding count.
But I guess what I'm trying to understand is this school, that every child in the school gets free lunch, is every student in that school counted in the at-risk funding? Or do we go back to the direct certification and the income for the members of that school?
Not every student in that school is counted in the at-risk funding count.
Okay. Representative Williams.
Thank you, Mr. Chair. I just have a few quick questions. So when you say certain medical benefits are included in the direct certification, would that include CHIP, children's health insurance? Because in Kansas, that can be up to 232%, depending on the age of the child.
I would have to check on that. I think CHIP is not included. It is only certain Medicaid benefits.
Okay, if you would
But I
double.
can check on that and see what that.
Awesome. If you could send that to us, that'd be super helpful. Also, I noticed in your audit that it said on page 19, I believe, that the census in 2023 stated that in Kansas, we'd have approximately 20% of our students that would fall in this 125% FPL. And what we're finding because of the direct certification, we understand there are other populations included in that, but we see double that amount, 41%. So my question is, it can only probably be a couple of things for that huge difference between 20% and 41%. Would the difference entirely be made up by those that might be homeless, foster care, or some of these other variables? Would that make up 20% of the difference? And if so, how could we be sure? Could we get some type of verification? Or B, is KDHE and DCF inaccurately providing those numbers, and therefore the direct certifications are not reflective of the proper income requirements?
So that difference is probably not going to be students experiencing homelessness and runaways, and migrant students and all that group of students, because those students are likely to have incomes less than 130%, and they would have been part of the estimate already. So it's probably not that. But there are a few things it could be, and so we actually listed a few of them on page 20. So One thing could be if KDHE and DCF are not accurately determining eligibility for Medicaid, SNAP, and TANF, then it could inflate the number of students who qualified for a free lunch. So in that case, the census count would be accurate, but the free lunch count would potentially be very inflated. Additionally, this could be fraud as well. Individuals who fraudulently seek benefits could also inflate the number of students eligible for a free lunch. And that could be fraud in any one of several programs. So that could be within free lunch itself, that could also be SNAP, that could be TANF, that could be Medicaid, so there's a lot of possibilities there. And then last, it is possible that survey respondents, because that estimate is based on the census. And so if the people who respond to the survey from the American Community Survey, if they're not reporting their income accurately, then that also could kind of move the needle a little bit and cause some of that difference as well. So there are a few things that could potentially be driving that big gap between the number of students we would expect to see and the number of students we actually saw.
Okay, thank you. I appreciate that. Looks like more to look into on that note. I have one more question, but I would say that's a huge question mark unanswered in the sense that we hear economically Kansas is doing better, but yet these numbers of at-risk kids are going up to 41%. So that's very alarming and suggests that our economy has been going down in the last 4 years, not up. So the last question is really about, it's on page 16, it's about the audits. It basically summarizes that an initial determination of eligibility is not allowed by the federal government. However, they do require the 3% to be audited. And in your audit, you pretty much express that the Kansas Department of Education and these local districts have no way to really verify other than what documentation is provided by those students' parents, like a pay stub. My question is, why can they not have, or can we not provide access, Department of Labor and Department of Revenue to verify 3%? Why is that not an option for KSDE to help districts to accurately verify?
First of all, it is unlikely that USDA would allow that. They are very particular about how verification efforts are conducted. They require, as you said, they require the school district to initially make a determination based solely on what was on that application. And then they only allow 3%. And you can't do more unless you have some cause. So it's only 3%. And USDA has historically been very picky about that. And so for one, I think it would be unlikely that USDA would allow the Department of Education, and certainly not the school districts, to do that. Second, at least the Department of Revenue, they have a lot of rules about who they can provide tax information to. And it may be that they are not allowed to send tax information to school districts. And so there would be a lot of hurdles to get over before that sort of system could be in place.
All right, thank you very much. Thank you, Mr. Chair. I think we do know someone that now works for the USDA from Kansas. We might have to ask him about this.
Senator Thompson.
Thank you, Mr. Chair. Thank you, Heidi. Great audit. So it sounds to me like the USDA is setting up a roadblock that makes it impossible for us to do the verification we need. Am I correct in that statement?
Yeah, we found that these rules originate with the USDA and how they have set up the program, and it's really not at all related to how the department or the districts have set it up.
So if that's the case and we can't verify it accurately, we're making two funding decisions based on something that we can't verify. One, the kids we need to feed, and two, the kids that need to achieve better. It just seems like I think your conclusion is accurate. We need to separate the two because it's two different problems we're trying to answer with one metric that is obviously way off. So thank you, Heidi.
Any other questions? All right, everybody, just remember, we've got to be on the next audit at 9:50. So Representative Tarwater.
Thank you, Mr. Chairman. On page 15 at the bottom, where you said that we might have overpaid by $38 to $53 million funding, did you take into account just the waiting for free lunch, or did you also take into account the high density at risk when there are a large value?
That number only includes at-risk funding, not high density. High density at-risk funding is based on the characteristics of the individual school. And so our projection was for the state, which meant we could not get into the details for each school district. So that 38 to 53 is at-risk funding. There certainly would be some overage in high-density at-risk funding as well. We just don't know exactly how much that is.
Okay, thank you very much.
Representative Sawyer.
Yeah, I want to follow up on the 38 to 53, how you figured the 38 to 53. Is that assuming that the same percentage of the 80% that are direct certified don't qualify as the ones in the economic survey? Or how did you deal with that?
That 38 to 53 represents only the problems that we saw in the 16% of the students who submitted that application. So when they submitted that application, we were able to verify that group of students. And we found that somewhere between 52 and 74% were likely ineligible. So that number is based on that. So basically, it assumes that the direct cert students are all accurate. It also assumes all the household economic survey students are accurate as well, and only includes that little bit that we could definitely verify. So this is likely a low number.
So the 16%, I have a hard time understanding why that group exists. I mean, what's the reasoning that they fill that out?
Those are the students who are not directly certified. So they are submitting an application in order to get access to free lunches. So they also are not attending a community eligible school. And so if you're not direct certified and you don't attend a community eligible school and you think you are eligible for a free lunch, the only thing you can do is submit an application, and then the school district will review that application.
Okay. I guess I have a hard time seeing there'd be that many people. It seems like most people that would qualify would fall under the direct certified. They'd fall into one of those programs.
And most of them do. 80% of all the
No,
free
but
lunch students.
that 60% actually seems high to me, that there'd be that many people thinking they qualify if they're not receiving any of those other programs.
Yeah, sometimes people don't apply for other benefits. They might be eligible for other benefits as well because they are eligible for free lunch. They could be eligible for other benefits too, but they haven't applied for them, and therefore they're not direct certified.
All right, thank you.
All right, Senator Petty.
Just kind of as a follow-up, so the at-risk funding is used for a larger population. I mean, this isn't really about that, but it's used for a larger population than the free and reduced lunch. So just wanted to clarify that.
It is the school that decides who receives at-risk services. And there is a reasonable amount of overlap between kids who get free lunch and kids who get at-risk services, but it is not complete. And it is the school district that ultimately decides whether or not a student needs at-risk services. And they don't necessarily consider free lunch. Like, free lunch is not a criteria. They're looking for lots of other things to determine whether or not that child needs at-risk services.
All right, we're going to move on real quickly. Frank, did you have anything that you want to say? I think Representative Williams has a question for you, if you come forward.
Thank you, Mr. Chair. Just one quick question. Of the 3% of the audits that are done by our local districts, what percentage of those are flagged for error?
So Frank Harwood, Deputy Commissioner for the Department of Education, I'd have to look into that. So if they are determined not to be eligible, then they are taken off. They no longer receive the, they would be taken off the school's at-risk count. I'd have to look and see what that number is. I don't have to off the top of my head.
Right. I would request that that be provided to our audit team and then provided to our committee. Thank you.
Any other questions real quick for Frank while he's up there? Heidi, I've got one question for you real quick. So migrants can get free lunches. What's the definition of a migrant?
A migrant student is a student who has moved at least one time in the last 3 years for specific agricultural purposes.
Do we have any idea what could that count be part of the difference between the number of people getting free lunches and what you found on the census data? Because in my community, most of our immigrants make far more than that.
No, I don't believe that would be it. That number is just not large enough. There just aren't enough of those students.
Okay, all right, thank you. All right, committee, thank you very much for keeping us on time. The next performance audit we have today is the abuse and neglect registries, and Josh is going to present to us on that. Welcome to the committee, Josh.
Thank you, Mr. Chair and members of the committee. As the chair said, I'm Josh Luthai. I'm going to be presenting the audit titled Evaluating State Agencies' Registries of Perpetrators of Abuse, Neglect, and Exploitation. In this audit, our primary objective was to look at whether agencies have complete registries of perpetrators of abuse, neglect, and exploitation. Our work suggests agencies' registries may be incomplete. However, we also learned the state's A&E investigation system is very complicated. That made it hard to say what agencies should be doing and whether their registries are complete. I'm going to talk about all of that in more detail, but I'd like to start out with some background information on page 4 of the report. State law defines what abuse, neglect, and exploitation each refer to. Abuse refers to acts that harm or may harm someone. Neglect refers to a caretaker not ensuring someone's safety or well-being. And exploitation refers to someone taking advantage of another person's resources, such as their money. And before I go much further, I'm going to be saying the words abuse, neglect, and exploitation a lot, so I'm just going to say A&E for that as I move on. State law makes 3 agencies responsible for taking allegations of suspected A&E. Each agency takes certain kinds of reports. We summarize which reports agencies take in Figure 1 on page 5. As the figure shows, KDADS takes allegations of A&E of adult care home residents. This includes, for example, people staying in nursing homes. KDHE takes allegations of A&E of residents of medical facilities. This includes people who are treated in places like hospitals. And DCF takes allegations of A&E of 3 different populations. DCF takes allegations of A&E of residents of state psychiatric hospitals and institutions for individuals with intellectual disabilities. DCF also takes allegations of A&E of vulnerable adults living in the community, so that would be places like their homes. And DCF takes allegations of abuse or neglect of children. Under state law, when one of these agencies gets an allegation of A&E, they're required to investigate it. Then they must complete a written assessment that, among other things, says whether A&E occurred. Agencies are required to keep a register or inventory of all allegations they receive and investigations they conduct. The agencies are also required to notify other entities about certain allegations or findings. First, KDADS and KDHE should notify DCF if they think a victim of A&E needs protective services. Second, all 3 agencies should notify regulatory authorities of findings of A&E involving licensed individuals. For example, if an agency finds a medical doctor may have abused someone, the agency should notify the Board of Healing Arts. Third, the 3 agencies should notify law enforcement about allegations that suggest criminal acts may have occurred. And fourth and finally, the agencies should notify the Attorney General's office when they refer allegations to law enforcement and when they determine somebody perpetrated A&E. So, with that background information in mind, I'm now going to turn to talking about the complexities of the state's A&E reporting and investigation system. If you turn with me to pages 8 and 9, you'll see Figure 2. Figure 2 summarizes how the state's A&E reporting and investigation system works. There's one main thing I'd like you to take away from this figure, and that's that the system is fairly complicated. It's a 2-page flowchart there, and I think we've even simplified some things. We're going to come back to that figure, but I'm going to move on to page 10 for a moment and discuss how requirements in state law are unclear, and as a result, each agency has approached its responsibilities differently. This helps explain why the A&E system is as complicated as it is. As I previously mentioned, state law requires the agencies to investigate allegations of A&E and determine whether A&E occurred. However, it's unclear whether the agencies should also determine whether specific individuals perpetrated A&E. It's also unclear whether the 3 agencies should keep lists of individuals who perpetrated A&E. State law says the agencies should keep registers of reports and investigations. It wasn't clear to us whether this means agencies are supposed to keep A, inventories of the reports they receive and investigate, B, lists or registries of identified perpetrators, or C, both inventories of reports and investigations and a list of perpetrators. And just to be clear, moving forward, when I say register, I mean an inventory of reports and investigations, and when I say registry, I mean a list of identified perpetrators. In working with the agencies, we found each agency interprets and carries out their responsibilities differently. So if you go back to Figure 2 on pages 8 and 9, I'm going to talk you through what each agency does. Starting with KDADS. State law requires KDADS to investigate allegations of A&E in adult care homes. KDADS is also separately responsible for certifying nurse aides. State law that's separate from the A&E statutes and federal regulation require KDADS keep a registry of nurse aides. That registry should also identify whether nurse aides perpetrated A&E. KDADS officials told us KDADS will investigate adult care home staff who either have nurse aide certifications or are unlicensed. And when I say unlicensed, I mean someone working like a janitor in an adult care home. They determine whether those individuals perpetrated A&E when they receive allegations. If KDADS finds one of those types of individuals perpetrated A&E, KDADS will identify them in the Kansas Nurse Aide Registry. And that's the registry KDADS keeps to satisfy the Nurse Aide Registry requirements in state and federal law. However, KDADS officials said they don't investigate adult care home staff with other types of licenses unless those staff also have nurse aide certifications. For example, KDADS wouldn't investigate a medical doctor or nurse who doesn't also have a nurse aide certification. Officials told us they lack jurisdiction over these types of staff. Instead, KDADS refers these staff to their licensing boards. Now, KDHE. State law requires KDHE to investigate allegations of A&E in medical care facilities to determine whether A&E occurred. We didn't identify any additional laws that clarify things like whether KDHE should keep registries of perpetrators. KDHE officials told us KDHE doesn't investigate specific allegations of A&E, nor does it determine whether specific individuals perpetrated A&E. And KDHE keeps no registry of identified perpetrators. KDHE officials told us they can't investigate allegations of A&E or keep a registry of perpetrators due to lack of authority, lack of resources, and because of an agreement the state has with CMS. Under the CMS agreement, KDHE officials told us they're limited to regulatory oversight. Instead, KDHE officials told us they oversee medical care facilities more broadly to ensure their compliance with statutes and regulations. Officials told us they refer allegations of A&E to other agencies, oversight boards, or law enforcement for investigation. And now, finally, DCF. State law requires DCF investigate allegations of A&E of vulnerable adults living in the community and allegations of abuse or neglect of children. Additionally, DCF investigates allegations of A&E in state psychiatric hospitals and institutions for individuals with intellectual disabilities under a 2013 MOU it has with KDADS and KDHE. I would note here that state law requires DCF receive allegations of A&E in state hospitals and institutions, but state law doesn't then explicitly say DCF should investigate those allegations. We didn't identify any laws that explicitly require DCF keep registries of perpetrators of A&E against adults or children. However, a few state laws suggest DCF should be keeping these registries to help facilitate things like background checks. DCF officials told us they investigate whether specific individuals perpetrated A&E against vulnerable adults living in the community or against residents of state hospitals. If DCF finds someone perpetrated A&E, DCF will add that person to their registry of perpetrators of A&E against adults. DCF officials also told us they investigate allegations of A&E of residents of adult care homes and medical care facilities when the alleged perpetrator isn't an employee or resident of a facility or home. For example, DCF officials told us they'd investigate whether an adult care home resident's family member financially exploited the resident by doing something like misusing the resident's money instead of paying their adult care home bills. DCF officials also told us they investigate whether family members abused or neglected children. If DCF finds a family member perpetrated abuse or neglect, DCF will add them to their registry of perpetrators of abuse and neglect of children. By contrast, DCF refers allegations of abuse or neglect of children by third parties to law enforcement. If law enforcement accepts a referral, DCF doesn't investigate it further. If law enforcement doesn't accept a referral or asks for assistance, DCF will investigate further. State law charges both DCF and law enforcement with investigating abuse and neglect in children, so it's not to us whether this referral practice aligns with legislative intent, and I'll talk more about the effects of that here in a minute. But first, I want to take a minute to talk about licensing boards. I've mentioned them a few times so far, and I want to explain how they fit into the picture. In this audit, we also worked with the Board of Healing Arts, the Board of Nursing, and the Behavioral Sciences Regulatory Board. When we started the audit, we thought these boards might keep registries of perpetrators of A&E. However, they do not, and they're not required to. The boards are responsible for overseeing the professions they license and investigating allegations of incompetence and professional misconduct. Acts of A&E are forms of misconduct. It's possible a board would take action against a licensee because of an allegation of A&E. However, the boards aren't charged with investigating allegations like KDADS, KDHE, and DCF are. And again, they don't appear to be required to keep registries of perpetrators of A&E. However, the boards do publish public lists of actions they've taken against their licensees. Those action lists may include cases where boards acted against licensees because the licensees perpetrated A&E. However, the action lists also include cases where the boards acted against licensees for other reasons. So, while the lists may include perpetrators of A&E, they are not registries exclusively of perpetrators of A&E. Now, I want to shift to talking about placement of perpetrators. So what a registry a person is going to end up on if they are found to have perpetrated A&E. Overall, the issues I've discussed here made it hard for us to evaluate whether the agency's registries are complete, and that was the main thing this audit was about. Additionally, the registries that do exist don't generally overlap, so we couldn't compare them to see if they were consistent and therefore complete. What is apparent to us, though, is there are a lot of places perpetrators of A&E may appear. If you join me on page 15, Figure 3 shows how perpetrators of A&E are placed on various registries or lists based on their licensure status and victim. As the figure shows, there are at least 6 places you might find perpetrators of A&E, and they don't generally overlap. If nothing else, this may make it hard for members of the public to know where they need to look to determine whether someone may have perpetrated A&E. I'm now going to shift to talking about agencies' referral practices. This content starts on page 16. As I mentioned earlier, agencies may refer allegations of A&E to other agencies, boards, or law enforcement. In some cases, agencies are required under state law to make referrals. However, we think some of the referral practices we learned about increase the risk alleged perpetrators aren't investigated and, if appropriate, identified. These risks could mean agencies' registries are incomplete. There are 4 issues I want to talk about. First, KDHE made referrals to DCF that didn't ensure alleged perpetrators got investigated. KDHE officials told us they referred 17 allegations to DCF in 2024. DCF determined it wouldn't investigate 14 of the allegations. That was because the allegations generally occurred in hospitals, which are outside DCF's statutory jurisdiction, or because the situation didn't suggest a need for protective services. And, as we previously discussed, KDHE doesn't investigate specific allegations. So overall, it would seem to us that no one investigated most of the allegations KDHE referred to DCF. Second, KDHE referred some allegations to only law enforcement. If those allegations were legitimate, it could mean the involved perpetrators weren't investigated and registered by a state agency. We reviewed 13 allegations. KDHE told us they referred to law enforcement in 2024 and 2025. Those allegations concerned a total of 25 alleged perpetrators. 23 of those alleged perpetrators were employees of home health agencies. That the allegations concerned home health agency employees suggests the allegations were about suspected A&E in victims' homes. We think such allegations would be under DCF's jurisdiction. DCF officials told us they investigate allegations against home health agency staff who perpetrated A&E in the community, which include places like vulnerable adults' homes. So we think KDHE should have referred those cases to DCF. Instead, KDHE referred them only to law enforcement. Law enforcement may or may not investigate these allegations, and regardless of what law enforcement does, no state agency investigated the allegations as state law suggests should happen. And should it have been appropriate, no agency would have had the chance to place identified perpetrators on a registry. Third, as I mentioned earlier, DCF refers allegations of abuse or neglect of children by third parties to law enforcement. If law enforcement accepts a referral, DCF doesn't investigate further. State law charges law enforcement and DCF with investigating allegations of abuse or neglect of children. But DCF officials told us they often don't know the outcomes of law enforcement investigations. So, if law enforcement finds a third party abused or neglected a child, DCF may not learn about it and therefore may not add that perpetrator to its registry of perpetrators of abuse and neglect of children. And fourth and finally, DCF didn't always refer nurse aides who perpetrated A&E to KDADS. KDADS investigates allegations of A&E against nurse aides who work in adult care homes. But nurse aides, which include certified medication aides and home health aides, may work in other places than adult care homes. We saw DCF investigated nurse aides on at least a few occasions. DCF told us it's their practice to notify KDADS when DCF finds a nurse aide perpetrated A&E. However, in 2 cases we reviewed, DCF officials told us they mistakenly notified DCF Central Office of findings instead of KDADS. Further, KDADS officials told us that even when DCF does notify them of findings, DCF doesn't provide documentation KDADS needs to update the Kansas Nurse Aid Registry in compliance with federal regulations. These issues suggest the Kansas Nurse Aid Registry may be incomplete. To try and start wrapping all this up, overall, like I've said, the state's A&E investigation system is complicated. State law is unclear in some respects, and agencies understand their responsibilities differently and have different practices. Their referral processes may mean registries are incomplete. And as I mentioned earlier, there are a lot of places members of the public may need to check to see if somebody is a perpetrator of A&E. On page 20, we list all the places some might need to check. There are at least 7 places, and some of those cost money or have other access barriers. If the intent behind the state's A&E investigation system is to protect vulnerable populations, then these issues may limit the system's effectiveness in doing so. We did make 4 recommendations as part of this audit. They begin on page 22. The first recommendation is to the legislature. We recommended the legislature consider amending state law to clarify state agencies' responsibilities. The remaining 3 recommendations are to each of KDHE, KDADS, and DCF. Generally speaking, we recommended the agencies consult with each other, the legislature, and others as needed to clarify their roles in the state's A&E system such that suspected perpetrators are appropriately investigated or referred, and, if necessary, placed on a registry. The agencies generally agreed with our recommendations, but KDHE questioned its ability to implement the recommendation without legislative action. Finally, the agency's official responses to the audit begin on page 24, and I believe they also submitted some written testimony to you all. That concludes my presentation. I would be happy to stand for questions.
All right, Representative Williams.
Thank you, Mr. Chair. Just a few quick questions. So first, do we happen to know the total number of individuals from these 7 different registries that are on the AIN registries?
I do not know.
And if so, okay, we don't know that. And then therefore, we do not know the number per license. We don't know the number for social workers or for nurses or any of those.
Yes, correct.
Okay, so my next question is, that would automatically be added to an individual's background check. But if those individuals don't have to, when they renew, if they don't have to have a new background check, which I think is normally the case, then those particular boards would never know. Is that correct?
I might defer to the boards on the answer to that. I think it depends on what sort of thing an individual is applying for. So for example, if I am a certified nurse aide and I'm applying to work in an adult care home, as a condition of my hire, I believe the home has to background check me in some capacity.
Okay, so if you're a new hire, they would, but if it's a renewal of a license, likely not. My only last question is, it says that the boards may investigate. However, if they get an affirmation of substantial evidence that there has been a somebody that is on the AIN list, then why is it that why would they need to investigate at all? Why wouldn't they want to move towards investigative action? Maybe I hold that question for somebody on the board, but it seems to me if they are on the AIN registry, may investigate isn't even necessary. It would seem that they would need to add that onto their list of unprofessional conduct or something of that. So that was a curious thing. I don't know if you have a comment on that.
I think there are two things going on there. First, the boards would investigate based on a referral to see whether that referral has a basis in reality. So for example, KDHE says we don't investigate allegations of A&E. We refer them to the boards. That means if KDHE gets a complaint about, say, a nurse, they might refer that to the Board of Nursing so that nursing can go in and figure out whether that nurse did in fact abuse somebody. So in that case, nobody before the board has done any substantiation. It's kind of falling on the boards to do that.
Well, I guess because we don't know the number of individuals that are actually on these 7 registries, and I'm sure that they are public. I believe you said that they are, so we could find that. Then again, it's curious if the name is on it because law enforcement has identified through their investigation or another entity that is able to investigate, those names for sure should be passed on to the boards, correct?
If an agency substantiates abuse, neglect, or exploitation against a licensed individual, they should notify the board about that individual, yes. And then the board, and this is the second component here, the board would investigate to decide whether they're going to do something like revoke the individual's license.
Didn't you say that there's not a path back for law enforcement to refer back to the board to get on the registry?
Right. So
There's not a process where criminal convictions wind up on the registry, is that right?
Right. So for example, if law enforcement, and this is getting away from the boards, but if law enforcement investigates an allegation involving children, they are not necessarily going to tell DCF about it, so DCF wouldn't be able to update their registry.
Sounds a little problematic and messy and a lot of missing pieces on, at least on the registry. We register people for all kinds of things, lapse licenses, but when we have serious incidences like this, there definitely should be mechanism to communicate back and forth between agencies and law enforcement.
Well, and to take it another step, help me if I'm right on this, someone files an allegation against you. In some instances, do they actually put them on the registry, even though we never went to a court? It's just an internal investigation and their name winds up on a registry. Is that right?
My name wouldn't just end up on a registry in this hypothetical. The agency would do the investigation and then they would notify me of the outcome. At that point, I have the opportunity to appeal, and I believe it would be a hearing before administrative appeals, if I'm correct. And then they would decide, you know, does the substantiation hold? If it does hold, then I would be placed on a registry.
Any other? Yeah, Senator Thompson.
Thank you, Mr. Chair. Thanks, Josh. There's a lot of questions here, really. I didn't see, is there a requirement to, let's say there's some a physician double billing or something like that, and they caught that. Is there a requirement to report that back up to CMS? Because I've had situations like that where I even call CMS, and they don't seem to care. Is that part of this? I was looking at that flow chart, and I couldn't tell.
Issues related to billing wouldn't be about abuse, neglect, or exploitation, so that's not something we looked at as part of the audit.
Okay. And then is there a lot of self-reporting from, for example, nursing homes or assisted living facilities where they may detect some A&E from a staff member, or is that pretty much internally handled?
My understanding is there is some self-reporting. Some of the referrals that we looked at that went to KDHE, those were, as I understand it, self-reports from hospitals and home health agencies.
Okay. All right. Thanks, Josh.
And so did I also understand that one of the biggest gaps that we have right now is, while KDHE may not investigate, they refer to the Board of Healing Arts, and they refer to the nursing board, but there is no mechanism to refer complaints about CNAs and other staff at the hospital, at the medical facilities, under the way KDHE does things right now.
I think there are referral processes in place. They just don't always maybe work as intended. For example, those DCF referrals that didn't make it to KDADS. I think the other kind of overarching issue is just how complicated the system is, how each agency takes a different kind of report, and it's not always clear where these reports are supposed to end up.
Well, and I kind of understand that separate registries because they have separate stakeholders, so to speak. That's maybe not the right term. But I didn't see one that actually refers to the CNAs and the medical facilities. Is someone from KDHE here? Do we have a member of? Hi, could you please state your name and title and?
My name is Jerry Smith. I'm the Bureau Director for Facilities and Licensing for KDHE.
Yeah, and I understand that most of your referrals you pass off to the boards in those facilities, but who takes care of like the CNAs and stuff like that?
So we would refer them to the appropriate board for CNAs, whoever administrates their licenses. That's where that referral goes.
And who is that board?
My deputy Bureau Director would do that. I believe that. I believe that would go to KDADS, but I'm not sure because I don't do that referral myself.
How about non-licensed staff?
Unlicensed staff. Anyone that we identify, and to understand what we do, we're a regulatory agency, so we don't always have that information, and it's not always reported to us. But when it is, we would refer that to law enforcement if they, or to the Attorney General's office.
Okay, thank you. Does anybody else have questions for any of the boards that are here, Senator?
Yeah, maybe for anybody on the boards, or perhaps you, there's some cases where there's elder abuse in a facility. Is there any kind of requirement to report it to family members?
So I would have to defer to KDADS because that is a long-term care facility.
And he's here representing KDADS. He wants to jump up and grab this one. Hi, state your name and your title.
Good morning. My name is Lacey Hunter. I'm the Commissioner of Survey Certification and Credentialing for KDADS.
So does a report end up back to a family member or somebody in those cases? I mean, a lot of times these older folks are pretty vulnerable.
It depends on the individual and the individual's care plan. So if the individual is caring for themselves, making their own self-decisions, and in their care plan doesn't have anyone that they want notified, nobody's notified. If that individual has a guardian, that care plan may look different, and the guardian's notified. If that individual has a directed plan of correction, wrong acronym. If they have a durable power of attorney for medical or for financial, depending on what that care plan for what that individual looks like, that's who's notified in those instances. But that individual, as an individual, has a right to their privacy and to have that kept to themselves if they also choose to have that.
Okay. All right. Thank you. Thanks, Mr. Chair.
All right. Anybody else have any questions? Senator Tyson.
Thank you, Mr. Chairman. I have a question for DCF.
Who do we have with DCF here?
Good morning.
Name and title.
Kritzi Khatib. I am the Deputy Director for Adult Protective Services.
Well, thank you for being here. Mr. Chairman, I've reached out to DCF several times on different instances across the state, tragic instances. And in this audit today, it said DCF will further investigate if law enforcement does not act. That has not been my experience. So could you address that, please?
I believe and I apologize because I'm with Adult Protective Services. I believe you're referring to Child Protective Services, and I would not have that answer. I could consult with our administration and get that answer for you. My apologies.
Mr. Chairman, if you would, and wouldn't there be a similar situation, how would adult handle it? I would like to know how children, but also how you guys would handle it too. Thank you, Mr. Chairman.
And Senator Tyson, would it be all right if you just restate that question because I want to answer that as correctly as possible?
So in the report, it says that if law enforcement decides not to move forward, it says that DCF will investigate further.
So when Adult Protective Services receives a concern, and our population is defined by vulnerable adults, and that's somebody 18 years of age or older that's been alleged to be unable to protect themselves. When we receive that concern, if it meets the criteria for assignment, we investigate it. If we suspect an alleged criminal offense has occurred, or we would then notify law enforcement and the Attorney General's office, we would complete that investigation. If the individual is substantiated, we once again notify law enforcement and the Attorney General's office of the substantiation. And again, that's after the individual goes through due process.
Thank you, Mr. Chairman. It just, I don't envy your job by any means, but the ifs in there, there's a lot of instances or scenarios where the ball could be dropped and there are harmful situations going on and they're not being addressed. And we do see this with children. I do. I get more calls with children than adult, but it is a problem. Thank you, Mr. Chairman.
All right, any other questions? And again, we've got some of the boards and other agencies out there. Okay, seeing none, thank you very much. All right, committee, we're a little bit ahead. We're scheduled for a break at 10:35, which is great. It's 10:20. Do we want to go on to the next audit, or do we want to take our 5-minute break now? If anybody wants their 5-minute break now, because I understand the urgency of those on occasion, raise your hand. All right. Oh, you do? All right.
If you want to continue.
All right, we're going to take a 5-minute break real quickly. And we will come back in at 10:25, so everybody go quick. To their seats, we'll get started again. I think we may have lost somebody in the break time. Next item on the agenda is the transient guest tax audit and Macy. There you are. Welcome to the committee.
Thank you. All right, Chairman Francis and members of the committee, my name is Macy Smith, and I'm going to present our transient guest tax audit. Kristen Roddinghouse was the audit manager, and Andy Brienzo, Matt Fahrenbrook, and Holly Alker were our team members. So in your packet, along with the audit, you will also see a couple of management letters. Those dealt with some minor issues, and I will not be delving into those today. The question we answered in this audit was, did select cities spend transient guest taxes appropriately in recent years? At a high level, we found that the cities we looked at, which were Overland Park, Manhattan, and Wichita, generally appeared to use their transient guest tax revenue appropriately. But there were a couple of caveats to that for Wichita and Manhattan, and I will explain those a bit later in my presentation. But first, I want to provide you a couple important pieces of background information. The first is I want to answer the question, what exactly are transient guest taxes? And these are taxes that Kansas statute allows cities and counties to charge to guests staying at hotels and other short-term lodgings, like maybe a bed and breakfast. For that tax to be charged, a city needs to pass an ordinance saying that they are going to charge it. Now, counties may also levy this type of tax. However, the primary focus of this audit is cities. Some aspects of the guest tax statutes important for this report are first, how statute says guest tax revenue may be used. Overall, uses that are allowed are tourism related, and generally these fall into three categories. First is tourism and convention promotion, so that's advertising. Then second is activities and organizations that attract overnight guests. So that might be sponsoring a local festival. And then third, it is specific bond repayments. And an example of a specific type of bond that may be repaid with guest tax revenues is a sales tax and revenue bond, a STAR bond. The other aspect of guest tax revenue statutes important to note is the 2% rate. That 2% guest tax rate may be a bit confusing because in Figure 2 on page 5, you can see at least 102 cities are charging more than the 2% rate in statute. And this leads to the other important piece of information I wanted to highlight. The Kansas Constitution grants a home rule privilege to city governments. This means that cities can exempt themselves from certain provisions of state law. And they can do this when the law does not apply in the same ways to all cities. And this does happen in the guest tax statutes, thus the home rule provision applies. When cities exempt themselves from provisions in the guest tax statutes, they have to do so by passing a special kind of ordinance called a charter ordinance. And this means that cities can exempt themselves from that tax rate, and so hence you have 102 cities with that higher than 2% tax rates. And they can also exempt themselves from statutory requirements of how to use guest tax revenue. In our work with Manhattan, Overland Park, and Wichita, we saw that while they did make changes to how guest tax revenues could be used, the cities still limited uses to tourism-related expenses, but they either added more details or expanded allowable uses to economic development. And I want to note that the specifics of how these three cities allow guest taxes to be used and what rates they charge can be found in the appendix of this report on page 23. I also want to note that when we say a city used their transient guest taxes appropriately, we were judging that based on what each city allows in their charter ordinances. Additionally, our findings only apply to the three cities we reviewed and for the 2021 through 2023 time period. I am going to be moving into the main body of our findings, and as I mentioned earlier, most of Manhattan, Overland Park, and Wichita's spending of guest tax revenue appeared to be appropriate. For that 2021 through 2023 time period, Manhattan spent $5.6 million of guest tax revenue. Overland Park spent $25.8 million, and Wichita spent $19.8 million. And if you look on page 7 in figure 3, you will see how those cities spent their guest tax revenue from 2021 through 2023. So while the categories of spending across the 3 cities were similar, the proportion of what they spent in each of the categories was different. And as you can see from that same graph, all 3 cities spent tax revenue for both tourism promotion and bond repayment for convention and tourism-related bonds. For all 3 cities, these 2 categories were appropriate expenditures. That first category, tourism promotion, is that marketing effort made to showcase each city as a place to come visit. You can see what each city spent on this category in figure 4 on page 9. From that 2021 through 2023 time period, Manhattan spent $3.4 million, Overland Park spent $5.8 million, and Wichita spent $7.4 million. The second category is tourism and convention-related bonds, and those bonds are used to finance projects that support or draw visitors to the city. You can see what each city spent on this category in figure 5 on page 10. Manhattan applied $1.6 million of their guest tax revenue toward repaying bonds for their conference center, a local sports complex, and the Flint Hills Discovery Center. Overland Park applied their guest tax revenue, a total of around $20 million, toward repayment of bonds used to construct a hotel next to the convention center, and also bonds for their soccer complex and convention center. Finally, Wichita repaid bonds for a downtown hotel with $971,000. And again, these all appeared to be appropriate expenditures. Another category of spending we saw was maintaining and operating tourism facilities. Wichita alone appeared to do this, and this is also an appropriate expenditure. Wichita owns the Century II Convention Center and other facilities like the Wichita Art Museum. As such, the city applied $11.2 million of guest tax revenue towards maintaining and operating those facilities from that 2021 through 2023 time period. The final category of appropriate expenditures was used by both Manhattan and Wichita. The cities both used guest tax revenue on direct grants or sponsorships for tourism. For example, Wichita is a sponsor of Riverfest, and that's an event that happens every summer and draws visitors to the city. For Manhattan and Wichita both, these were a small portion of their expenditures. So in those 4 different categories I just talked about, tourism promotion, bond repayment, maintaining and operating tourism facilities, and sponsorships and grants, the 3 cities appeared to use their transient guest taxes appropriately. However, we also found some expenditures made by Wichita and Manhattan that were either inappropriate or unclear in their appropriateness, and these findings start on page 12. The first expenditure was in 2023 by Manhattan. The city transferred $100,000 of their transient guest tax revenue to the general fund. Manhattan's charter ordinance for guest taxes is broad and allows City Commission to determine if the expenditures are related to tourism and conventions. The commission did approve the general fund transfer, but a lack of written documentation of how the money was to be used and then how it was used meant there was not enough information to determine if this was an appropriate expenditure or not. Now, in Wichita, from 2021 through 2023, they used $16,000 to cover city administrative and audit fees. This is inappropriate because Wichita's transient guest tax ordinance does not include fees for these types of administrative services. This likely occurred because it is standard practice in Wichita to divide these types of expenses across all city funds. Now I am going to shift into discussing another finding we came across during our audit work. And to better explain this, I need to provide you some background on the guest tax collection process. If you look on page 4, and specifically figure 1, you can see how that process flows. You have the guest who pays the tax, then the hotel who who remits that tax to KDOR, then that money is processed and 98% of what is collected is distributed to the city. So having that context, I will continue now at the bottom of page 13. KDOR collects transient guest taxes from businesses, and they are doing it for about 107 cities. But when KDOR collects, they are using state statute, not the individual city ordinances, which as I discussed earlier can be changed, and they are using state statute to determine which businesses should be remitting transient guest taxes to KDOR on behalf of guests. What this means is that when cities' transient guest tax ordinances are different from state law, there is a risk that KDOR may not collect the tax correctly. And so if you look on page 14, you will see that we found that since 1992, KDOR may have collected and Wichita may have received transient guest tax revenue from guests at some hotels and other lodgings that were not authorized in Wichita's charter ordinance. Wichita's ordinance levies a transient guest tax on guests staying in businesses with 9 or more bedrooms. And according to state law, taxes are collected on businesses with 3 bedrooms or more. So there is a difference there. Also, the Wichita ordinance does not authorize the city to levy transient guest taxes on guests paying for sleeping accommodations like an Airbnb. And so state statute, though, does allow this. So then in both instances, Wichita has authorized fewer businesses for guest taxes to apply to than state law does. We do not know how much in guest tax revenues KDOR may have collected or Wichita may have received that did not align with Wichita's charter ordinance. KDOR estimated that of 106 accounts submitting last fall, 5% had less than 9 rooms. This likely happened because neither Wichita nor KDOR have processes in place to review state law and city ordinances for those potential conflicts. You will also see that we had another finding about Manhattan's 2022 and 2023 annual comprehensive financial reports not being filed timely. These were reports that are in essence the city's annual financial audits. The late filings had impacts to the city's bond ratings. Manhattan officials told us they were understaffed and have begun using an external accounting firm to help. Wrapping up here, in summary, Manhattan, Overland Park, and Wichita all spent their guest tax revenues differently from 2021 through 2023, but most of their spending did appear to be appropriate with a few caveats. We did issue a few recommendations to Wichita, KDOR, and Manhattan, and you can see those and the responses there starting on page 16. And finally, I want to point you again to the appendix section of the report, which discusses in more depth each city's specific tax rate, allowable uses, how guest taxes were used each year, and gives some brief historical context. And that concludes my presentation, and I'm happy to stand for questions.
Have any questions for Macy? Representative Tarwater.
Thank you, Mr. Chairman. I've got a couple of questions on the appendix, page 26. For Overland Parks, so the way I understand it is that these cities are only breaking a law if they didn't change the law to match what they're spending the funds on.
I'm going to repeat what I think I heard. Yeah. They aren't breaking the law if they change the ordinance.
Right.
That is correct.
Okay. So on page 26, it says 1% of their collections can be used for capital projects, and part of that is such as improving or maintaining or operating a convention center or hotel. Mm-hmm. But then on page 27, they issued $90 million in bonds for rehabilitation of 322 guest rooms. So are they breaking their own law there?
I I can't speak to that, but I did want to point you to the up to 6% may be used to repay the Overland Park Development Corporation bonds per their debt service support agreement. And it is my understanding that when they reissued bonds, that was again through the Overland Park Development Corporation. So that would fall under that 6%.
Okay, so if they issue bonds, they can get around their own law that they changed from the state law so that they could still do it.
Can you say that again?
Okay, so I guess there's more than one way to skin a cat. I mean, if we say they can collect 2%, they changed it to 9%. We allow it only for certain things. They can expand that. And even if they want to go further than that, as long as they issue a bond to do it, they can pay the bond off. And that's fine too.
I'm going to let Overland Park speak to that if they want to. Because I'm not, without digging in and seeing how everything's structured in detail, I don't want to say, yes, you can, or no, you can't.
Okay.
Do we have someone from Overland Park here? Do you want them to come forward, Representative, or do you want to wait?
Sure. Yeah, I'd have a couple of questions for him.
Yeah. Could you come forward and state your name and your title?
Good morning, committee. I'm Mike Koss. I'm the city attorney for Overland Park. Yeah. Oh, yeah, I'm sorry. Can you hear me now? Yeah, Michael Koss, city attorney for Overland Park.
Representative?
So I guess my initial question is, in 2000, you issued $92 million in bonds to finance the construction of the hotel. And then you charge 9% to all the other hotels so you can compete against them and pay for your hotel. But those bonds were issued 25 years ago, and now the balance is $139 million. How does that happen?
We had 2 refundings since the initial bond issuance. We had one in 2007 and another in 2019. Those funded certain renovations to the facility, along with getting a better interest rate on the bonds long term.
So again, you started with $92 million, and now it's $139 million after 25 years of paying for it. And that's because you renovated the same buildings? Or you reissued the same bonds at a lower rate, but the amount went up pretty dramatically?
I mean, there's inflation, there's interest. I'm not a finance expert. I didn't look at the structure of those bonds, but I mean, it was all for the underlying initial expense to finance those facilities, to improve them over time. And I can't speak to the veracity of that overall number now, but yeah, there were a couple reissuances.
Mr. Chairman, it's just not, my math, it doesn't add up for me, but maybe they missed payments on bonds for a long time and then had to reissue them. But $92 million doesn't go to $139 million over 29 years of paying for them, if you're paying them on time. Thank you.
Do we have any other questions on the audit, or Senator Thompson?
Actually, it's for Macy. Did I understand you correctly, Macy? These have to go for star bonds, or can it, I mean, the way Overland Park's doing it is through their own development bonds?
Star bonds is an option, but there are other types of bonds.
Not required. And then with regard to the, the home rule, they charter out of home rule. So can the state really do anything about that when they charter out of these?
No, not unless you want to do something different with statute.
Statute or the Constitution?
You could probably do that with statute, but you'd have to make everything apply.
Uniform, correct. So right now, it's not uniform 2%. It's just, is it by cities of class? Is that what the difference is?
The difference is having to do with if a county, in state statute, if a county charges, then the city's not allowed to. So that means one city in a different county can, but the city with the county that charges can't. And that's part of that non-uniformity.
But if the state law was uniform, you can't go above 2% on transient guests, then cities or counties could not, correct?
That is my understanding.
Okay. All righty. Thank you. Thanks, Mason.
Senator Tyson.
Thank you, Mr. Chairman. I have a question for the city attorney. I don't know how long you've been there, sir, but why on earth does the city own a hotel and compete against private industry?
Well, I guess I don't know that I would agree that we're competing. We pay those same transient guest taxes that all the other hotels in the community. I'm sorry, can you hear me? Yeah, we pay the same transient guest taxes and sales taxes at those facilities as any other hotel in the city.
And if I may, Mr. Chairman, you do not see yourself as competing against other hotels in the area?
Well, I don't think they do. They're very supportive of that facility. They appreciate the opportunity to have this sort of iconic facility that draws visitors into the community. When people come to our conventions, which is our convention center has been named the top small convention center in the country for the last 4 years, those visitors don't just stay at the Sheraton. They stay at other hotels, and I think, those other hoteliers appreciate that.
So, Mr. Chairman, I understand this is a little off topic, but we have passed government competition bills to rein in this type of effort. It absolutely is a direct competition to private industry, and that's not what our government's about. So, thank you, Mr. Chairman.
Representative Williams.
Sure, thank you, Mr. Chair. So really quick follow-up on Representative Tarwater. So I'm sure these are revenue bonds, not GO?
They are TGT backed. Correct. There is no GO backing of these. That's correct.
Okay, and so is there a percentage or a threshold that the Olathe put in their charter ordinance that allows only a certain amount of your revenue from the transient guest tax to be used for these? I missed that.
That is correct. It's 2/3 of the total rate. So it would be 6% of that total 9%. That's accurate.
Okay, and again, we could, at the state level, make changes, but it has to be parallel across all cities. Thank you.
Senator Tyson.
Thank you, Mr. Chairman. So are you paying property tax and sales tax also?
Yes, the hotel does.
The hotel did not have a property tax abatement for 10 years.
Not that I'm aware of. No, I know we're paying property taxes now.
Right, because that 10-year abatement would be up. But did you have an exemption for 10 years not to pay property taxes?
If we did, that was before my time, Senator. I apologize.
Okay, thank you, Mr. Chair.
Senator Petty, is that a move that you want to ask a question?
Well, seems that we're getting somewhat off topic. I mean, we are dealing with transit tax, so the conversation about whether municipalities own any type of property, whether it's a hotel or whether it's, a variety of things. A recreation center is definitely a local decision, and their communities make those decisions. And this seems to show, this transient guest tax post-audit shows that all of these cities have been using their transient tax appropriately. So I'm sorry to see us getting off topic here.
Any other questions? I've got a question. Is somebody from Wichita here? Yeah, could you come forward and please state your name and title?
Yes, sir. Good morning. My name is Mark Manning. I'm with the City of Wichita Director of Finance.
Okay, thanks for being with us today, Mark. Hey, do you guys have this figured out, how we're going to fix this inconsistency between your charter and state law?
Yes, sir. First of all, I'd like to thank Macy for her audit. She pointed out some stuff that frankly we weren't aware of. KDOR is a fantastic partner for the city of Wichita, and we definitely will address that. Our governing body obviously will have to pass a charter ordinance to amend our stipulations, but we will present that to them this fall to do.
All right, so you guys have plans to address that inconsistency?
Well, sir, in all honesty, staff has a plan. I can't speak for our
Yeah.
governing body, as you know. But yes,
You know how those elected officials can be.
staff will present options to the governing body to remedy the situation. Yes, sir.
All right, okay. Anything else? All right, seeing none, we'll move on to the next item on the agenda, and it's the Office of Inspector General, and we have a presentation by Matt. A different Matt than our earlier Matt.
Yeah, the other Matt. Okay. Thank you, Mr. Chair and members of the committee. My name is Matt Fahrenbrook. I will be presenting our limited scope audit, reviewing the results of the Office of the Inspector General's audits and investigative work between calendar years 2021 and 2024. Katrin Osterhaus managed the audit, and this audit was requested by Senator Pat Petty and approved by this committee on May 3rd, 2025. This audit had one question: how much state general funds has the state recovered due to the direct work of the Office of the Inspector General, and how many of the office's investigations have resulted in a prosecution? And once again, we looked at the time period 2021 to 2024. In short, we found that the Office of the Inspector General's work between 21 and 24 has resulted in 2 prosecutions and the recovery of about $1.3 million in federal and state funds to date. To unpack this, I will begin by discussing some background information starting on page 3 of the report. Kansas offers 3 main medical assistance programs to eligible residents. Medicaid, which is a joint federal-state program, provides health coverage to certain low-income groups. The Children's Health Insurance Program, a joint federal and state program, provides health coverage to uninsured children who do not qualify for Medicaid. And then Medican is a state-funded program that provides temporary health coverage to individuals applying for Social Security disability benefits. The Kansas Department of Health and Environment, or KDHE, is the primary agency responsible for administering these programs. However, the Office of the Inspector General also provides program oversight. A little bit of background on the office. In 2017, the legislature established the OIG as an independent office within the Kansas Attorney General's office. It was previously part of KDHE, but had been inactive since 2014. The office reopened in 2019 with a new Inspector General, and the current Inspector General was confirmed in April 2021. The office now has 10 staff members and is responsible for audits, reviews, and investigations to ensure the accountability and integrity of the programs that it oversees. Between calendar years 2021 and 2024, the OIG published 5 audits, 3 performance reviews, and 1 interim audit covering various medical assistance programs. Additionally, the office screened over 5,500 complaints and opened 280 investigations. Most of the complaints came from the Department of Children and Families and alleged benefits eligibility fraud. The other complaints also came in from OIG's hotline and from other agencies, law enforcement, and individuals. In this audit, we reviewed all 9 audits and reviews conducted by the OIG from 2021 to 2024 to identify confirmed monetary recoupments, excluding unrecoverable funds and projected savings. We interviewed OIG officials and examined supporting documentation, including materials from KDHE. For investigations, we analyzed the OIG's case list and reviewed cases that involved prosecution or financial recovery. Now I will discuss the audit results beginning with OIG's investigations on page 6, specifically figure 2. From 2021 to 2024, the OIG reported opening 280 investigations. At the time of our review, 59% of the investigations were still open with no results yet. 25% were closed without action because either the allegations were successfully disproven, there was a lack of sufficient evidence to continue, or the involved losses were too small to pursue. And 9% were referred to other law enforcement or regulatory agencies. The remaining 8% of investigations, OIG data showed that authorities had taken some form of action, such as removing ineligible beneficiaries from program roles or pursuing prosecution. At the time of our review, 7 investigations had been referred for prosecution, and 2 of those had been prosecuted. Now, skipping ahead a bit to page 9, the 2 investigations that have been prosecuted have resulted in the state recouping about $1,000 to date. One case involved a defendant who misreported their household income to qualify for Medicaid and received services valued at between $25,000 and $100,000. In 2023, the individual entered into a diversion agreement requiring $2,500 in restitution and about $642 in court fees. Court records we reviewed showed that they stopped making payments in May 2024 after submitting about $920. A hearing is scheduled for this August to consider revoking the diversion agreement, which could lead to an increase in the amount of restitution required of the individual. The second case involved an individual who forged documentation to falsely claim a pregnancy to qualify for Medicaid. In April 2025, the individual agreed to a plea deal requiring $5,042 in restitution plus additional court fees, the estimated value of the benefits received. Now, in the report, when our report was finalized, it was prior to that June 30th. I can now provide an update that that deal was indeed approved by the court on June 30th, 2025. So returning to page 8, I will continue by discussing the OIG's audits and reviews. In our review, we focused on funds that OIG identified as having been recouped by the state. We identified one report published in September 2021 that documented the recovery of about $1.3 million. The report found that KDHE had paid about $1.3 million to 4 managed care organizations between 2015 and 2020 for 25 deceased individuals. And just a note for those of you who may not be familiar, managed care organizations are paid a fixed amount of money per beneficiary, regardless of whether the individual receives services in that period. So the report noted that after OIG's review, KDHE was able to recover $1.1 million of the overpayments by docking the payments for 3 of the managed care organizations. And the remaining $171,000 was recovered through the direct payment from the 4th organization, which was no longer working with the state at that time. We reached out to KDHE, and they were able to provide data confirming that the full $1.3 million was recovered. And it should be noted that the $1.3 million recouped was likely included a mix of federal and state monies, since Medicaid is a jointly funded federal and state program. We also categorized about $3.2 million in future savings and about $320 million in wasted funds resulted from OIG's work. For context, we provide an overview of these figures starting at the bottom of page 10. However, we did not evaluate the validity of the numbers as part of this limited scope audit. We also did not make any recommendations to OIG based on this audit. At this time, I would be happy to stand for any questions.
All right, do we have any questions? Senator Tyson?
Thank you, Mr. Chairman. I just was curious on page 5, 2024, the increase in staff and the number of investigations opened. Do those correlate?
We did not run a correlation analysis on that. However, we do recognize that with the increase of staff, all their staff came in 2020, since 2023. And so prior to that, their ability to conduct investigations was a lot lower, and the IG can speak to that some more as well. So I would say that it was correlated, but yeah.
Thank you, Mr. Chairman.
Senator Petty?
Thank you, Mr. Chairman. And so, from the audit that's done, so 1.3 million is what has been recovered that went back to through that one case. And as been paid back from the in future funds from the MCOs. Is that correct?
That is correct. And when we say future funds, it was at one point future funds, but it has been recovered.
Right.
Yeah, that is what we confirmed. Yeah.
Future in that point. And then, other than that, it's $1,000, and with the case that now has been settled is $5,000.
Correct, yeah. The case that the recent plea agreement would have been for, about that 5,042, which is the restitution that's been ordered. Of course, as we can see in the previous case where the $2,500 in restitution was ordered, obviously they stopped making payments, and so not all that has been recovered. So, but that is what has been
1,000 to
ordered.
date. Right, 1,000 to date. Is that correct?
Correct, yeah.
So, and that's in correlation to the fact that we have it's the office of, that through this office, we have now 10 staff, but this is based on, it would be the work of 6 staff. Would that be correct?
We didn't look at specifically how many staff were working on each investigation. That would probably be a question for the IG. Or are you referring to what the staffing levels were at that time?
Right, I was just looking at the staffing
Oh, okay,
levels
yeah.
at that time. So because since 21, we've gone from 4 to now in 24, 10 additional staff with this kind of recoup of funds.
Yeah, I mean, the IG can speak to more of how they disperse their staff work, but yeah, that would be our understanding.
Thank you.
Okay.
Representative Williams.
Thank you. Just a quick question. So on page 7, you have a breakdown of the 69 investigations, or 25%, that were closed, and your audit includes that 36 were disproven, which is great for those individuals that cleared their names. But did you get a breakdown for the remaining other half, approximately, that was it because we didn't have enough evidence, or is it just minimus amounts?
I could get that breakdown for you, but for brevity, we did not break that down here. The big distinction there was that really that the disproven investigations are considered successful investigations because there is an outcome and an outcome to that investigation. In that case, it is disproven and the individual is vindicated.
Okay, thank you.
Yep.
Representative Tarwater.
Thank you, Mr. Chairman. I have a question on page 11, the very last bullet point, where you said that in 2022, Home and Community-Based Services, OIG found the state paid over $193 million for beneficiaries that shouldn't have received it, because they were no longer using it. However, there's a requirement that says they have to stop paying it if it's not used monthly. So how does that happen? There's no system in place to find out if somebody had used a benefit the month before and they just continued to pay for it?
So that would be a good question for the IG to speak to the specifics of that. Like I said, we did not, we provide this as an overview, just as a summary of these their results, but we did not dig into these because these were not defined as recoveries or prosecutions.
Thank you. Thank you, Mr. Chairman.
And just so everybody knows, the office, Stephen Anderson with the Office of the Inspector General has some prepared remarks and is available for questions. So if we want to do that at this time, we can do that, unless someone has something that they want to ask the second Matt. All right, seeing none, we'll go ahead and have the prepared remarks from the Office of the Inspector General. Welcome to the committee. Please state your name and title.
Steve Anderson, Inspector General. Chairman Francis, members of the committee, thank you for allowing me to speak today. I also want to thank the Kansas Legislative Division of Post Audit for their audit and the work that they did and working with them. I want to emphasize a couple of points. Before fiscal year 2024, when the Kansas Legislature provided funding for 2 special agents and 1 analyst We had no ability to conduct investigations. We were purely an audit function. No functionality existed. I did not have sworn people. I didn't have an investigator. We were purely auditors and myself, an analyst. So when you look at some of these investigative results and why didn't more investigations happen, you can't do investigations if you don't have investigators. It's that simple. I also appreciate the KPLA auditors talking about the disproven investigations or successful investigation. That is true. I firmly believe that. For anybody who's ever been wrongly accused, to be exonerated is a real plus. So those don't add dollars. They don't show up as recoveries. They don't show up as savings. But for the people who are subject to those investigations, it's a win. I also understand that due to the limited scope of the audit, we were unable to confirm certain savings identified by our office, by our investigative work. However, to provide clarity, we felt it was necessary to include additional information in our response, which is in the response you all have. Most importantly, we do not claim savings from an investigation unless we confirm that the Medicaid recipient has been removed from the Medicaid program. In the list of investigations that our office provided to KLPA, we identified $375,446 in savings. That are people that are removed from the program because they were found to be ineligible, and we cut off the capitation payments that were being placed to them. We use a one-year calculation for that. We know that SSA-OIG, they use a 5-year window. I think that's excessive. We use a 1-year window. So we look at the capitation that are savings. So given how little time we've had and the small size of our staff to conduct the number of investigations we have, I feel really good about that. Be more than happy to answer any questions you may have.
Do we have any questions for the Inspector General? Representative Williams?
Thank you, Mr. Chair. Okay, so if we're on that KDAD's audit for the 2022, and I may have missed it, do you have plans to audit that particular program, the HCBS, again?
Actually, we do. We just recently had our entrance conference with KDHE and KDADS, and we're looking at that very issue because it's been about 3 years and it's time.
Right, there's a lot of money here at stake, and I'm going to ask a question of KDADS if they're here later.
Yeah, do we have someone from KDADS available? They may not be up to speed on this one, but yeah, why don't you come up, Representative, and we'll get the question asked now, and then
I'm Deputy Secretary Andy Brown with KDADS.
Thank you, Mr. Chair. So really, this is a follow-up for the $193 million that was identified by the Inspector General, and KDAD said that they would make some improvements. So my question to you, what improvements did you make since that audit in 2022, and how has that changed so that we are correctly paying the capitation rates? Also in the audit, it said that you were not going to recover. So if you didn't recover, were there notifications for those that were offering these services so that they knew that they had either incorrectly, consciously, unconsciously, fraudulently, or infraudulently turned in numbers for capitation?
Yes, that's a pretty lengthy answer. And so it might be easier for me to put something together and send it back to you guys. But we've implemented several things. One of those is our electronic visit verification program, which requires logging in and logging out of the system so that those visits and services can be more adequately tracked. We've also been working on our HCBS cap, which is going to be looked at in this next audit. And we'll be looking at the same time period for this audit, I believe, as we looked at for the previous audit. But we'll also be sort of providing updates about the steps that we've taken since then to help remediate and eliminate some of those concerns.
So just the last follow-up on that, do you do internal audits? Because when you get a number with that much waste in it, did you go back and verify that? And are there continuous internal audits? And if so, did you do one again in 23? Did you do one again in 24 to just ensure that this is not a continued problem, even though you did have the new electronic verification system?
So I'm not certain what all audits have occurred since the last OIG audit at this time. And that might be that audit role might be a KDHE role too, so I need to check on that. But I will take the questions back and try to provide a response.
That would be great, Mr. Chair, if we could find out if they do internal audits and if when they get these reports from the OIG, if they go and look for verification and then the next year follow up on it again. Thank you.
Senator Tyson.
Thank you, Mr. Chairman. I just wanted to ask the Inspector General, and thank you very much for your work and efforts. Do you only look at medical programs, or are you auditing other programs in the state also?
Currently, or for this time period, it was strictly medical, Medicaid, Medican, and CHIP. As of the July 1st of this year, we have been given authority to look at SNAP, TANF, and other cash and food assistance programs.
Does that include the school lunch program, free?
I think it would fall in there.
Okay, thank you, Mr. Chairman.
Senator Thompson.
Thank you, Mr. General. Are there, just in general, are there other inspector generals in every state, or and is the staffing similar, or just selective states have an OIG?
Certain states have OIGs. Texas is an example. They have a very expansive IG office. Other states have little or no IG function. I'm really the only independent IG in the state of Kansas. I understand DOT has a non-independent IG working within their function, and that's it. So it really varies from state to state and the size of the staff. Florida has an incredibly large IG function that covers almost every facet of government there, whereas other states like Arkansas has a statewide IG, but then they have a Medicaid IG within that function. Tennessee is similar.
Okay. Thank you.
Any other questions? Okay. Seeing none, thank you very much. All right. Next item on the agenda is the base 1.0 and 2.0 matching funds, and we have Cade to present on that.
All right. Okay. Thank you, Mr. Chair and members of the committee. I'm here to present the limited scope audit reviewing base 1.0 and base 2.0 grant program planned matching expenditures. There was just one question for this audit, and that was what types of spending did the Department of Commerce allow recipients to include as planned matching expenditures in their base 1.0 and 2.0 grant award agreements. We've had a few recent audits of the base grant program, so I won't cover too much on the background since you've heard a lot of that information already before. But I'll start on page 4. And just, very briefly, just to recap, the base grant program was created by the SPARK Committee, administered by the Department of Commerce using federal ARPA funds for economic development and projects impacted by the COVID pandemic. There were 2 separate rounds of funding and application review. There was the base 1.0 program in 2022, and then the base 2.0 program in 2023. So we'll move on to the matching requirements piece. There are no federal laws or rules in ARPA or elsewhere that would require matching funds for base grant program recipients. All the federal rules for ARPA fund grants pertain only to the grant funds themselves. There's no rules for matching funds, and there's no requirements for the use of matching funds. And then similarly, there are no overarching state laws or rules in Kansas that automatically required matching funds for the base grant program. Instead, it was the Department of Commerce that created a 25% matching requirement for the base grant program. So that means that at least 25% of the total cost of a base grant project had to come from the award recipient's own funds. The Department of Commerce also allowed recipients to count pre-award expenditures, project-related expenditures, as part of the matching requirement. Land purchases could count if they were made on or after January 1st, 2021, and then other project-related expenditures could count towards the match if they were made on or after January 1st, 2019. We asked department officials about the matching requirement and why they chose to allow pre-award expenditures to count towards the match. They told us that they created the matching requirement to leverage additional money for the grant projects. And they also told us that they allowed pre-award expenditures to give recipients credit for work that they had already completed on the grant projects prior to the date of the actual award. So for example, if they had started the project prior to the COVID pandemic. And then next we'll turn to our main findings on the planned matching expenditures, starting on page 7. So we reviewed a total of 72 base grant award agreements, 35 from base 1.0 and 37 from base 2.0. Each award agreement that we reviewed had a planned, essentially a planned budget section where recipients listed their planned matching expenditures, and then those budgets were approved by the Department of Commerce. And it's important to note here that these are just planned expenditures. So once a project is complete, the actual expenditures may differ somewhat from what was in the agreements. And the planned matching expenditures were generally broken up into 3 overall categories: construction, non-construction, and administration. Construction, that encompasses things like labor, materials, site work, like demolition, soil boring, that kind of stuff. Non-construction, that encompasses costs that are not construction and are not administrative, so things like land purchases and fees to consultants, stuff like that. And then administration encompasses payroll and other general administrative costs. And I'll note here, you can see it on the bottom of page 7 as well, but there were 2 award agreements, 2 of the 72 that we determined were outliers, just because their planned matching expenditures were so much larger than all of the other award recipients. So we've kind of separated them out from the results so you can see what those look like. Figure 1 on page 8 shows the expenditure breakdown from our award agreement review. And so overall, construction costs were by far the largest category in terms of planned matching expenditures, accounting for $226 million in total dollars, which represents 83% of all planned expenditures. And as you can kind of see in the figure 1 there, materials and site work were large categories of expense for the non-outlier recipients. And then for the 2 outlier recipients, materials and other/general expenses were large categories of expense. And just kind of a note there, other general expenses, that includes things like, in this case of one of the outliers, included things like general construction on a stadium. And then you can see in the figure as well that non-construction costs accounted for $45 million, or 17% of all planned expenditures, and administration accounted for $2.6 million, or about 1% of all planned expenditures. Of the administration expenditures, about $1.6 million was planned for administrative payroll. On page 9, you can see we also looked at the split between planned pre-award and post-award expenditures, which is shown in figure 2. With all 72 recipients included, so including the 2 outlier recipients, about half of all planned expenditures, about $135 million, were pre-award expenditures. And then without the outliers, so with just the 70 other recipients, only about 35% were planned for pre-award expenditures. And then last on page 10, we cover some issues that we encountered with the accuracy and completeness of the base grant agreements that we reviewed. There's some more detail on that page. I'll kind of cover the highlights here. At a high level, there were some differences in the amount of base grant funding that we compiled from the award agreements versus what Commerce officials reported. So, for example, the 37 base 2.0 agreements that we reviewed listed total grant funds of $45.5 million. Commerce officials told us that they had initially awarded $49.5 million in grant funds, but 2 recipients declined their awards, resulting in $45.5 million. And then department officials told us that they still plan to award an additional $4.5 million in base 2.0 grant funding for a total of $50 million overall. But at this point, it's unclear how the department will award those remaining dollars. There were also several instances that we encountered where the amount of listed matching expenditures in the award agreements was inconsistent with that same amount listed elsewhere in the agreement. And Commerce officials told us that these were likely errors and that they did not check for these errors before approving the agreements. And then lastly, there were 2 recipients that we reviewed whose planned matching expenditures were lower than the 25% requirement set by Commerce. One of them had matching expenditures that amounted to 24.4% of the total project cost, and the other one, their planned matching expenditures amounted to 24.6%. Commerce officials told us that these agreements were still approved because the reviewer likely rounded those amounts up to 25%. And just to note, we do have an appendix at the back of the report that lists all the recipients and their planned matching expenditures and their grant funds as well. With that, I can stand for questions.
You have any questions for Cade? Representative Williams.
Thank you, Mr. Chair, and I'll be brief. So on page 10, with your findings, it said that they gave you 37 awards. The website said 39. They had reported 38. Did they ever give you any documentation at all about the others that they said were terminated or combined, or indicate which ones were terminated or combined? Or did you ask for those?
Yeah, so we tried to reconcile what we had received from, in terms of award agreements and then what was listed on the website. We didn't receive documentation for the ones that they said were terminated or declined. They did tell us which ones from the website were no longer active because they had been terminated or declined. So we did end up with that same 37 number, but we didn't receive documentation for those.
Okay, it might have been interesting to look at those agreements. The next bullet point that you provided, it says the department did not provide us with documentation confirming. So, but you did ask for it, but they declined?
Can you, which?
The second bullet point on page 10. There was a difference in the amount of base grant money, 45.5 million versus 49.5.
Yeah, so that's the same thing that I was just talking about. So they told us that 2 agreements had been terminated, and so that was the difference between 45.5 and 49.5, but we did not see, they did not provide those 2 terminated.
So they're just holding the 44.5 million. They're just holding that money. That money's still there.
We're not, it's not clear to us what's happening with that money currently.
Thank you.
Any other questions? Senator Tyson.
Thank you, Mr. Chairman. Can we ask for a follow-up from that on legislative post-audit to delve in to find out the representative's question? Because we do need to know where that money is, and we'd like to know why they were terminated too. The companies, you said, did not accept the grants, and I would be curious as to why. What changed?
Can you ask what ask Commerce what they're going to do with the 4.5 million, and then you also want to know the reason the 2 were declined? Is that right? Or no, they didn't decline. They didn't accept it. Yeah, so we want to know what the reason they stated that they reviewed. Okay, you guys can ask them. Someone else want to say something? Representative Williams.
Thank you, Mr. Chair. So is Commerce here so we can ask them questions? They are not here. Okay, so I do have questions for Commerce. There are many unanswered questions here, and it does tie back to the other audits. And the letter that we received from the Lieutenant Governor and the Secretary of Commerce, very unsatisfying. And so I don't know how this particular committee gets to the bottom of this when a lot of this has been deflected. So I'm not sure where to take my questions.
I think you can make an inquiry. I think the agency's attitude is that this program is closed and shut down, and read their letter.
I did read the letter, and I would just have to make a formal concern relating to that, because we are a serious legislative post-audit committee, and we are asked to evaluate these. And actually, the federal government does recommend that their dollars, their ARPA dollars, be audited. And so when we get a letter that says that this is a waste of taxpayer money, I would say that's not a good excuse for being frustrated that we're auditing them, because I think any company does self-audits, or have secondary third-party audits to make sure their dollars are properly used. We have a judiciary responsibility, and we're not getting answers. And so I mean, at this rate, maybe we need a fourth audit, because it's really frustrating that this is minimized, and we still don't know where some of these dollars are.
Senator Tyson.
Thank you, Mr. Chairman. And I think it demonstrates a pattern of behavior. It's not just these audits that we're finding problems with. Almost every single audit that I'm aware of that's recently been done with the department has shown inaccurate or misappropriated, whatever it may be. It needs to be looked at. And if we have to, we can invoke the authority that this committee has in order to get this information. Thank you, Mr. Chairman.
Senator Petty.
I haven't been on this committee as long as some others here, but I am at a loss. There's been 3 audits, so I'm somewhat at a loss of the fact that saying that there hasn't been a response. And when, I can understand asking for who it was that turned down the ARPA money, but that is a local decision or a personal decision about why they did. There is $4.5 million there that the department could respond back about how that will be used, but to me, it does appear to be overkill, I would say, if we are looking for more than just response to those two particular things of knowing. I don't know why we really need to know who said they didn't want the money, but if people want to know that. But it appears that, this money came into the state of Kansas. It's being used to grow businesses in Kansas, and that's exactly what we wanted to see happen with the ARPA funds. So I'm at a loss as to this attitude towards commerce.
Do we have any other questions for Kate on the audit? Okay. Seeing none, we'll move on to the next audit. And we've got John and Aging and Disability Resource Center changes. Josh, welcome to the committee.
Thank you, Mr. Chair.
Or John, I'm sorry.
That's all right. Thank you, Mr. Chair and members of the committee. My name is Jonathan Jones, a performance auditor with Legislative Post Audit, and I'm here to present the limited scope audit evaluating Aging and Disability Resource Center contract changes. This audit was requested by Senator Billinger, and the objective was to answer the question, why did KDADS change how it contracts for Aging and Disability Resource Center, or ADRC, services? The short answer to the question is, KDADS officials told us they changed the ADRC service contract for 2 main reasons. The first reason was to limit the appearance of a potential conflict of interest, and the second was to address longstanding performance issues with the Home and Community-Based Services, or HCBS, waivers assessments. To add a little background context for the program, this begins on page 3. KDADS is the agency which oversees the ADRCs. The ADRCs were created by federal law. In Kansas, the ADRCs the ADRCs offer services to Kansans who are aging or have disabilities and need long-term services and supports in order to continue living in their communities. The ADRCs do this by providing information, referrals, and assistance through a statewide call center. They also provide counseling services and an access to a database of providers. Until the contract change, the ADRC services included functional assessments for the Medicaid Home and Community-Based Services, or HCBS, waivers. These waivers allow states to provide services to individuals living in the community instead of institutions like nursing homes. A functional assessment is a tool used by states and providers to collect information on individuals applying for and using HCBS services. The ADRCs are a collection of services that are contracted to an entity, and that entity that receives the award functions as the Aging and Disability Resource Center. KDAD's contracted with Area Agencies on Aging, or AAAs, to provide the AAA services. In Kansas, there are 11 AAAs that are either a unit of county government or a private not-for-profit corporation. From 2012 until June 2025, each of the AAAs acted as a local ADRC and offered these ADRC services. The AAAs also offer a variety of aging services in addition to the contracted ADRC services. Figure 1 on page 5 shows some of the different services the AAAs provide and services that are offered through the ADRC. In 2024, KDAD's made the decision to split the single contract for ADRC services into two separate contracts. The previous contract with the AAAs ended June 30th, 2025. The first new contract is for an organization to provide the functional assessments for the HCBS Medicaid waivers. KDAD's awarded this contract to Maximus U.S. Services. The second contract is for an organization to provide the remainder of the ADRC services. This contract was awarded to Liberty Healthcare Corporation. On the right side of Figure 1 on page 5, you can see the new contractors listed with the services provided in each contract. I'm now on page 6 for those of you who are following along, and I'm going to discuss the main reasonings for changing the contract. There were 2 of these. First, KDAD's officials told us they had concerns about the potential perception of a conflict of interest. They told us this change to the contract was a precautionary measure to help ensure they do not violate any federal guidelines. There are CMS requirements that prohibit an entity from providing case management or developing an individual service plan from also providing HCBS services. These requirements are meant to prevent self-referral. The AAAs did not develop service plans or manage individuals' cases, but KDAD's officials had concerns that the AAAs completing the HCBS waiver assessments, while also providing certain other services like options counseling or nutrition services, could be perceived as creating this scenario. We spoke with CMS officials, and they told us they did not require KDADs to make this contract change. KDAD's officials said by separating the assessments, this should ensure that there is no conflict of interest. The second reason was due to long-standing timeliness issues with the waiver assessments. According to KDAD's performance measures, the AAAs did not complete timely HCBS waiver assessments. Kansas is on a quality improvement plan with CMS in relation to the state's performance being below the minimum threshold. KDAD's officials told us they think by having a separate contract for the assessments, it will allow the contractor to focus solely on the assessments, which should create efficiencies to help address this timeliness issue. Finally, KDAD's told us they advised the AAAs to bid on both new contracts. However, they would not award both contracts to one entity due to the conflict of interest concerns. The AAAs submitted a bid for the HCBS waiver assessment contract, but did not win the award. Due to technical issues, the AAAs did not submit a timely bid for the ADRC services contract. Figure 1 on page 5 shows the AAAs still offer the aging services, however, they do not offer the ADRC services anymore. We did not make any recommendations in this audit. That concludes my presentation, and I'm happy to stand for any questions.
Any questions? Senator Tyson.
Thank you, Mr. Chairman. Thank you. Who did win the audit for the assessment?
The assessment was Maximus U.S. Services.
Okay, thank you, Mr.
Do you have any idea how much the area agencies were cut in funding as a result of this change?
I do not. We didn't look at the outcome of the contract change. We just focused on why KDAD's made the decision. But perhaps KDAD's or the AAAs might be able to speak to that.
And I know the AAAs have some brief prepared remarks. Do we want to hear those at this time, Or does somebody have any other questions for John? All right, let's go ahead and have Leslie Anderson come forward and deliver her prepared remarks. Please state your name and title for the record, Leslie.
Good morning, Mr. Chair, members of the committee. I am Leslie Anderson. I am the Executive Director of the Kansas Association of Area Agencies on Aging and Disabilities. Thank you for the opportunity to provide brief comments on the limited scope ADRC audit. Since you have my testimony and my comments based upon the limited scope audit, I'm just going to take about a minute of your time. From my understanding, if there isn't a conflict of interest, that leaves performance as the reason to change how KDADS contracts for the ADRC. My written testimony provides examples of outcomes when using unpredictable management information systems. I'm referring to the assessment system of record and the system of truth that KDHE uses for Medicaid programs. When processes, systems, and tools are unreliable, the outcomes reflect a lack of compliance, reduced inefficiencies, lost revenue, and reputational damage. Our greatest concerns are the fragmentation of the ADRC and creating a silo that will adversely impact access to long-term supports and services in the state. I know all of you have questions when it comes to performance, but I want you to take into consideration what I just mentioned, the processes and systems that the ADRCs were required to use, and they used, and the data was unreliable. With that, I'll close and I'll stand for questions.
So can you tell me how much funding did you guys lose as a result of this change, do you know, system-wide?
About $5 million a year, and that includes assessments as well as options counseling. Estimated.
And then, you know, Maxon, I guess, is that right? They got the contract, right?
For the assessments.
And then, so where do they have their representatives located? I mean, I know you guys are throughout the state, and of course, I'm from a very rural part of the state, so I mean, you can have my region and you're still 60 miles away from me, but how are they doing these assessments? I mean, how's that happening currently? Do you know?
It would have to be a question for KDADS.
Okay.
But I can tell you the area agencies on aging traveled. That's in the contract that it has to be face-to-face, except when there is flexibility like COVID and right now during the transition where they could use virtual or telephone assessments. But every one of the counties was covered by an assessor.
And that $5 million that you talked about earlier, what percentage of your total funding was that $5 million? Do you have any idea?
I do not have an idea, but if you need that answer, I can provide that to you.
And then the services that you're not providing any longer, were those kind of block grant, or were they on a per service provided?
Fee for service.
Fee for service, okay. Any other questions? Representative Williams.
Thank you, Mr. Chair. So I wanted to follow up on the untimely assessments, and according to KDADS, they say that they are on a quality improvement plan. I'm not sure when they were placed on the quality improvement plan because of these untimely assessments. But in your letter, you explain that and you give us some data on that indicate that it is a website problem or they're not actually following the law in terms of who might be eligible. They're not removing those. So I guess my question is, did you have communication? Because it says that there's been a problem since 2013. Did you have a communication with KDADS that you weren't in error of filing late, or here are the problems, or here are the website problems? Is there a actual trail that shows that you were in communication during that time period?
Yes, and that's quite a few questions. Let me see if I can answer that. So as far as the data, let me give you an example. So KMAP, which is the Medicaid system, will show an individual is open and they have Medicaid, okay? ks will show that that individual has moved. In a couple of instances, that individual moved out of the country, no longer eligible for Medicaid, let alone HCBS, but it shows up on a report called the Fallout Report, which shows past due reassessments. Individuals are deceased, they're not closed, so of course the capitated amount continues to be paid. The ADRCs are required to use a change notice called a 3161, and when those are not processed according to whatever the process was at that time, including now, because it has changed, then it continues to show that an assessment was due, but it was not because it's no longer open. And of course, that looks like a performance issue. It looks like that's not a timely assessment when that is not the case. That's why I provided that percentage in my testimony to show that it's not clear, and what you see is really not necessarily either using the system of truth and the system of assessment records, because none of that was changed accordingly.
Well, Mr. Chair, just to follow up on that, but did you have constant communication with them that these are inaccurate, here are the reasons? And if so, wouldn't they have rectified that so they wouldn't have been on a quality improvement plan with CMS?
So personally, I started this job in 2019. So since 2019, yes, I had monthly conversations because there was a monthly KDADS, KDHE, and the ADRC meeting. Before my time, the ks, which is the system of assessment, was used strictly for the aging programs. So Jonathan had mentioned other programs such as the nutrition program under the Older Americans Act. That was the system they used for their data entry, data collection, billing, et cetera. And then when managed care came into Kansas, ks was expanded to include all of the HCBS. And there were conversations between KDADs and the AAAs, to my understanding, that there were issues with the data. So, for example, assessments could not be found. And that was addressed in one of the Inspector General's previous audits. And then all of a sudden, that information was there. So we had numerous conversations. K4AD requested $1 million from the legislature to put together a data steering committee to analyze ks and to make improvements using the feedback from internal and external data processing experts. And I'm not sure where that money is right now. So we have taken steps to help improve the efficiencies as well as improve the data reliability.
Senator Tyson.
Thank you, Mr. Chairman. The ks system, isn't that an in-house system developed by KDADs themselves?
I'm not sure how they developed. It is not an off-the-shelf.
No, it's a custom system, and they're, that's what's interesting. So since they contracted this out to Maximus, are they going to continue using the ks system or another system? And the reason I ask this is because, to me, this raises some major security possibilities.
We've got someone with KDADs if you want them to come forward. Maybe, who do we have with KDADs to help us with this? Andy, this is your day. Yeah. All right. Senator Tyson, you want to?
Yes, I've posed the same question.
And state your name and title again.
Andy Brown, I'm the Deputy Secretary for KDAD's programs. So with regards to the security issue, so ks is a system that we operate. It's maintained by the state. If there are security issues that come up with the system, those are addressed by our IT staff. We're not aware of any security issues with regards to the platform at this time.
Mr. Chairman, thank you. You're changing contractors. So I guess I would ask how this relationship between the area agencies has gone on for years. I mean, 20, 30 years?
Since 2013, I believe, is that right, for the ADRC?
Longer than that.
2008.
It was actually before that, but.
Well, I know that there's been AAAs in the state, but the ADRCs are relatively new, or not as old as 30 or 40 years.
Okay. But they were using the KMA system for an assessment system.
Yes.
And who was doing the assessments at that time then, if it was prior to?
So the AAAs were doing the assessments for those specific waivers that were part of that ADRC contract.
Right, for years. So why all of a sudden, why did this, I don't know, I'm just trying to understand a little bit of history here, Mr. Chairman, because this audit, it's intriguing to me that all of a sudden it went out for bid, and I just want to know some history on that.
So it's always gone out for bid. When we were first awarded a contract, the AAAs bid for that, they were awarded that bid. After 5 years, we rebid it. At that time, the AAAs were selected again. This year, they did not submit an application.
But isn't it also true that you told them that they couldn't provide the services they're currently providing and also do the ARDC, that you wouldn't put the two together?
We put out 2 separate bid opportunities, and we told the AAAs to apply for both of them so that they could be considered for either one.
That's right. It would be either one. There was no opportunity to have both like they currently have.
That's correct, and that's because we were trying to remove the potential, right, of there being any kind of perceived conflict of interest.
Senator Tyson.
Thank you, Mr. Chairman. How many companies bid on the?
So we had 2 that bid for the assessment and 1, I believe, that bid for the ADRC.
And a national company one, or is Maximus International? I'm not familiar enough with.
Well, I would say national, yes.
Thank you, Mr. Chairman.
Representative Williams.
Thank you, Mr. Chair. First of all, that is a little bit concerning that you had someone from our state that was operating it. I don't know if there's record or actual communication, written communication that gave them the deadline and that they could apply for both. So if there is, that would be good to know if there's written communication that verifies what you said, but also that KDAD's just accepted the singular bid. That doesn't seem, it seems like there should have been, that doesn't seem very wise. I mean, just go ahead and accept one bid when you had someone, and there's a lot of other things going on, but that's a side point. I want to look at the letter that was submitted to us by Leslie A. Anderson, and I wanted to know, first of all, about the IT situation. We continually, from the legislature, fund IT. We're constantly doing that. We are happy to do that, but we want it to actually be effective. And so my question is, with $1 million appropriated, and we can get the exact numbers, were those monies spent? And when did you know that there are some problems with your users being able to, make all the system work together and talk together and have the interface that's necessary?
So the money was not spent, and it was actually not reappropriated either. So right now, we do not have $1 million to spend for that purpose. The reality of the KMS system, right, is such that it is sort of a legacy system that we have had operating for some time. We are aware that there are issues with it. We do work to try to address those issues. as they come up. So that's what our current stance on that is we're working to make sure that it's as effective as possible. But we are working within the system itself to try to do that. So we're not looking for an outside system to replace it at this time.
Was it KDAD's request? Was it an agency request for the 1 million, or was it a request that came outside from example, the AAAs?
It came from K4AD, I believe.
I'm sorry?
It came from K4AD, I believe, from the AAAs.
Okay. And as a follow-up, you could provide this later, but I would like a response based on page 11 for those expired reassessments, trying to understand what your response was to CMS, and if you explained that some of those are a problem with your data system and the communication between the two, and that according to this, most of those expired reassessments shouldn't have even been on that list. So if you can follow up with that information, verifying or not, if this is accurate, and also if you shared that with CMS for your prior to your improvement plan.
Yeah, so I don't know that we share specific details about individual reports that we provide to the AAAs with CMS. But CMS is aware of the efforts we're making to try to address the issues that we have within the system. So the cap itself is a document we can share with you, Representative, so you can review that and see what's in there. That's a large part of what the OIG audit is going to be around, is looking at those issues. And I do think like this choice to separate the two contracts will probably be part of what we cite as examples of what we're trying to do to address those issues.
Senator Tyson.
Thank you, Mr. Chairman. Would you also follow up with us? I don't see how this solves your problem, since CAMUS is an internal system, and how Maximum's national company is going to be able to do on-site assessments. I'm just curious how the department plans on addressing some of this.
Yeah.
Thank you, Mr. Chairman.
And I can just real quick just explain that like Maximus has the same regional approach. So there will be regional Kansans that live here in Kansas and do assessment work. They'll be going out to communities and visiting with people in their homes, doing face-to-face assessments the same way they've always been done.
Senator Tyson.
Thank you, Mr. Chairman. I understand, but they're not currently hired, or may not be hired. Do they have the experience with the assessments? I mean, those assessments, if I remember correctly, they have more data, and you guys may not be aware of this. They've got financial, demographics, health. I mean, it is amazing what is in that system. And so I just want to make sure that we're doing the best we can for our constituents. Thank you, Mr. Chairman.
Certainly.
Representative Williams. You know, one of the bad things about being a chairman that doesn't ask his questions first is sometimes we run out of time for me to ever get to ask anything. Anyway, go ahead, Representative
Be
Williams.
super fast.
No, you're fine.
I was just looking at Maximum US because Senator Tyson is so knowledgeable on IT issues and threats, and I just looked up their shareholders. Their number one shareholder is Fidelity Management, and their number two is BlackRock. And so having our sensitive data out there on a national scale, of course, I appreciate Senator for bringing that up.
Any other questions before I ask mine? Anyway, so help me understand this regional approach. I mean, one of my biggest concerns is sometimes in the interest of efficiency and concerns like what you're expressing, we lose access to care in the rural areas. You know, there's a certain economy of scale that you need to be able to provide in a rural area. And when you pull $5 million worth of funding from Western Kansas, I'm concerned that you start to make some of the other services provided by our area agencies, they can't provide them any longer because they don't have the revenue streams to support their operations. How do you address that? They've lost $5 million of funding, and we don't have population density in my part of the state.
Yeah. So the $5 million that they're losing was largely for a contract that was essentially a cost-based sort of contract. So the majority of those funds would have gone to pay the salaries of the assessors and for the programming that's done by the ADRC. Most of those services and functions are still going to be happening in Kansas. There's still going to be Kansans that are working for these companies providing that work. So the majority of that $5 million is likely to stay here in the state, within the communities, and in many cases employing the same individuals that were doing the assessments under the AAAs.
I just think sometimes that's a naive understanding of what happens in rural Kansas. You know, you've got to have a certain amount of business at a location to maintain that location. And if you don't have it, if you're in a town of 4,000 or 5,000, I'm afraid you're losing sight of the big picture on this thing. So they lost $5 million worth of funding. How much was the contract with, is the contract estimated to be with the successor organizations?
Yeah, hang on for just a second. You have the dollar amount? So we don't have the dollar amount with us here today, but we can get that for you.
And they're mainly federal reimbursements, is that right?
So
for services, or how much of it is state money that's matching and stuff?
Yeah, it's a match, and I think it's in the 60-40 range, 50-50 match.
Right, and you don't know what the new contract estimated. Was there a improvement in cost by this organization? I mean, are they doing it cheaper than what the AAAs were?
I'd have to review that. I'm not certain.
Right. Okay. Well, I've got some real concerns about this. You know, when you're out there in Goodland, Kansas, you know, you need every client you can. Has there been an improvement in you stated some concerns as far as their services. Has there been any improvement in those concerns?
So we just started the new contract within the last couple of weeks. We don't have a lot of data to present at this point.
Right.
Either.
We don't have people hired to provide this in my part of the world yet.
People have been hired, and we're in the transition process. So well, all I'm saying is like right now I don't have like a full month's worth of data to look at to compare.
Yeah. Okay. All right. Any other questions? Okay. Seeing none. Thank you very much.
Thank you.
All right. Committee. I see Allie Devine out there. Allie with Devine, Donnelly, and Murray is providing lunch for us today as we work through this. Thank you very much, Allie. Would you like to say something?
Thank you, Mr. Chairman. I was getting a little nervous. The sandwiches are warm. And you can tell Dan ordered them because it's a Cubana or a brisket sandwich. It's beef or beef. And then we have 3 vegetarian salads. We have enough for 20. So if staff wants some, please help, but I need your names. So thank you. It's ready.
Yeah, thank you very much. Okay. All right, committee. The next audits are follow-up audits. Do we have people in the audience that are here for the follow-up audits? Go ahead. Do we have people in the audience that are here for the follow-up audits? Committee, do we want to go ahead and do the follow-up audits real quick so we stay on schedule? Okay, we'll go ahead and do the follow-up audits. Kristen?
Sure. Thank you, Mr. Chair and committee. I can keep this short so that you all can get your sandwiches.
Business is more important than our lunch plans, so don't ever worry about that, Kristen.
Okay. So I'm going to walk through, just for clarity's sake, a couple of different materials, again, and try to keep this brief. But I'm going to go through the results of the follow-up audit. You'll see in there that there's a handout that KLRD put together. And then you also have a copy of an old audit report that we released in 2022 on the tax credit for low-income student scholarship program. So I'm going to kind of briefly mention all 3 of these materials as I work through them. So starting with the follow-up audit first, it is, as the name implies, this is where we go back and look at old recommendations from our past audit reports to see whether or not agencies have implemented them. So in this particular follow-up audit, we followed up on 6 recommendations from 3 audits that we released in 2022. If you turn to page 4, that's the first audit that we followed up on. And I should mention, actually, before I do that, that Sarah Middendorf is the auditor who did this audit. She's actually, her last day with our office was Friday, so I am presenting in her stead. So if you'll turn to page 4, the first audit that we followed up on was an audit of foster care services. And there we looked at 4 recommendations. You can see those in figure 1, which is on pages 5 and 6. And so in each of these cases, the department, in this case DCF and KDADS, had responded to us saying that those recommendations were implemented, and then we in this audit go back and ask more questions and follow up and then reach our own determination. So that determination is the status that you're seeing in the figure. So in the foster care audit, we were looking at the safety of children in foster care, and we found that DCF generally had adequate written policies, but that the agency and its case management providers didn't have adequate practices to do that. So we issued these 4 recommendations, and for the sake of time, I'm going to focus on the 2 that we determined are only partially implemented, which is recommendations 3 and 4. So recommendation 3 was essentially asking DCF to use performance data to identify systemic issues and influence corrective actions. And so through our work, what we saw is that DCF had done some work to conduct quality assurance interviews and to put together like a QA report, but there weren't any signs that that actually influenced their corrective actions with the case management providers. And then the second, or what was recommendation number 4, to DCF was to include key elements in their case management system. And the reason that this was, we determined to be only partially implemented, is that that system is actually still being developed. So it's currently in the RFP process, but they did provide, DCF did provide documentation showing that at least their plans for that system would include many of those elements that we suggested in our recommendation. Moving on to the second audit that we followed up on, you can see this on page 7. And that was our limited scope audit of social workers employed by school districts. So one of the issues that we found in that audit was that the districts we worked with were inconsistent in reporting their mental health staff, including social workers, to KSDE. And if you look at figure 2, which is on page 8, you'll see what we found in our results here. So we had recommended that KSDE develop guidance to districts to fix those inconsistencies. And what we saw in our documentation this time around, our documentation review, is that KSDE has developed that guidance. So they do instruct districts to report staff FTE by role, not license, and then also provided some clarity on instructions of where to report social workers and which reports and which ones to exclude them from. And then the third audit that we followed up on starts on page 8, and that recommendation is in figure 3 on page 9. This was us following up on the limited scope audit of the tax credit for low-income student scholarship program and scholarship granting organizations, or SGOs. So in this audit, we evaluated whether SGOs had dispersed at least 90% of the contributions that they receive for student scholarships within 36 months, because that is a requirement in state law. So here's where I will reference, at the beginning of my presentation, I pointed out you also have a copy of our actual 2022 audit. And there, if you want to follow along, if you look at page 6 and figure 3, that's where you can see the results of our work in 2022. So what we found is that 2 of the SGOs at that time had not distributed all of its contributions within the 3 years as required by state law. And the reason that those two SGOs didn't comply with that distribution requirement is that they told us they lacked eligible students to apply. So you all have made changes to statute since we did this 2022 audit, which does expand the students who would qualify for this program. And then in this report is also then where you will see the recommendation that we issued, again, which was to KSDE to request and analyze monthly contribution and disbursement data so that they could continue monitoring SGO's compliance with that distribution requirement. So at the time we did that 2022 audit, there was not monthly information available, so we could only do a kind of a more blunt annual comparison. And so the recommendation was to try and get more granular so that they could really focus on the 36 months that are in state law. So when we did this work, what we learned in this audit and the follow-up audit is that KSDE did, following our 2022 audit, ask districts to start, or asked SGOs to include monthly contribution data in the information they report to KSDE, but they did not ask for monthly distribution data. So again, why this was only partially implemented. They have half of the information, not the other half, so they couldn't actually have the historical data to follow up on that distribution requirement. They told us that as of their June 1st, 2025 report, which was actually after we finished our work on this, that they were going to ask for 3 years of monthly data on both contributions and distributions so that they could monitor that requirement. That covers both of those audits. The handout that you also have from KLRD, this is something that you all requested one of your latest meetings for some updated information, which KLRD has combined from both its, I think, KDOR and KSDE's reports on that information. So with that, I'm happy to answer any questions from the committee.
I also want to make sure the committee knows Andrea Warnke with the DCF is online and she's available for questions if anybody has any questions for her. Okay. Senator Tyson.
Thank you, Mr. Chairman. Not a question. I just want to thank Andrea and DCF. I know they have difficult jobs. We appreciate their work and hope that we can work together to make these processes better. And I know that they are making an effort to implement your recommendations, which is good. Thank you, Mr. Chairman.
Any other questions or comments? Okay, seeing none, very good. Thank you. All right, committee. It is now time for our lunch break. And then at 1 o'clock, we're going to have our OITS presentation. They're not in the room by any chance, are they? Okay, all right. So we'll go ahead and take our lunch break at this time, and then we will reconvene at 1 o'clock. Okay, thank you.
All right, when we get to professional services, again, I'll break this back down into a theme of there's about 3 categories we support of services. Our primary and our professional services are user account services, and that is the management of a OITS domain that provides support to OITS, D of A, and a handful of non-cabinet agencies. Again, these are within a domain or an environment that OITS specifically manages, and that includes user management, so creating new user accounts, removing user accounts when people leave, desktop support, patching, things like that. That is handled by this group, print management, server management. And when we break that down, again, that is specifically to an environment we manage and don't manage, that we manage specifically. Along technical services, these are those ad hoc support I was talking about. Again, we'll create a statement of work for an agency and bill them on an hourly basis. This is not something we do a lot of or frequently of because, again, most of the agencies that may need this already have their own IT support in their own IT environment, and this is based on if we have resource availability. One of the other pieces we have is what we call desktop as a service. We have facilitated a desktop leasing program. Our current program is through Dell, and basically as an agency needs a device, they contact Dell, they lease the device, Dell ships that device to them. And in most cases, most agencies do that interaction directly with Dell. Our previous contract had OITS as an intermediary. We have kind of made it so we are not a intermediary to most agencies. They're contracting directly with Dell for that process. All right. So one of the things as we look at it, and again, I know this is a question that's popped up, is our service management. So OITS and the Kansas Information Security Office has maintained a service catalog for some time that agencies can see the services we provide. This is something that we're taking a very deliberate focus based on feedback from audits and feedback from legislative committees to really clearly define and make sure understandings exist between agencies and the service they're providing. So we recognize that as a challenge. We've undertaken a project specifically to document every agreement with every agency we're providing services to. The challenge is that we'll kind of highlight here is we have a lot of dissimilar environments, so we're going to have 96 potentially very different agreements and what that looks like. So that disparate or differing agreements does create some confusion in where your service may stop, where we pick it up, vice versa. And so we want to make sure we're walking through and clearly delineating what those look like. So we do have an active project. I have tasked my agency by the end of the calendar year, we have all those agreements in place with each agency. They clearly outline roles and responsibilities between us and the consumer of those services. So there are no questions with that. All right, so that is a very high level. I'm going to hand this off to our Chief Information Security Officer. We're going to leave time for questions at the end, if that is okay with you, Mr. Chairman, so we can address them all at one time. Or if you'd like me, sir, I can answer questions about OITS right now.
What's the will of the committee? Do we want to ask questions now, or do we want to keep going through the presentation? Huh? Keep going. Okay.
All right, so I'll hand it off to our Chief Information Security Officer.
All right, thank you, Jeff. Committee Chairman, members of the committee, I'm John Godfrey, the State Chief Information Security Officer. A little background about me. I started in this role in January of 2024. Prior to this, I was the former Chief Information Security Officer and Associate Vice Chancellor for Information Security at the University of Kansas Medical Center. I've been in cybersecurity for over 18 years, including a global CISO role for a social media startup, and most recently served as CISO in residence for my own consultancy. In terms of educational background, I hold 3 bachelor's degrees in information technology, networking, telecommunications, and criminal justice. Earned a master's degree in information assurance, and I'm currently pursuing my doctoral degree in cybersecurity. So a little background about the Kansas Information Security Office for you. It was established in 2018 under the Kansas Cybersecurity Act, or KCA. It was created to advise and consult agencies on information security matters. It integrated foundational cybersecurity services into the core OITS service offerings that Jeff was talking about. It provides advanced cybersecurity services to agencies on a fee-based model. The operating budget was funded through OITS collected fees, and it was staffed at that time with approximately 10 full-time professionals. If we fast forward to today, the current state, we have 42 FTE positions. We operate a cybersecurity internship program with a great amount of success in that internship program. The annual budget is approximately $11 million. Starting in fiscal year 24, there's $5.75 million in state general fund and $5.25 million in off budget. We provide cybersecurity services across the executive branch and for OITS provided enterprise services. And as Jeff had mentioned before, the state CISO in this role has the authority to set statewide cybersecurity policy. Kind of a high-level organizational structure for our cybersecurity program. We have a division of cyber collaboration and cyber preparedness. We have the Deputy Chief Information Security Officer. And then we get into some of the operational aspects where we have cybersecurity operations, the Information Assurance Division. Under the Information Assurance Division, we have our Information Security Officers, or ISOs, if you've heard us talk about that term in the past, and they work directly within the agencies to assist them with the cybersecurity activities. And then on cybersecurity operations, that's where we have our Security Operations Center, or SOC. You may hear us use the term SOC. And then we have our cybersecurity engineering, and we'll break this down just a little bit more here as we go forward. So specifically in operations, we have the SOC that we've been working hard to continuously build out and provide 24/7 capabilities. We design, implement, and manage technical cybersecurity tools in this part of the team. We monitor those tools, looking for alerts and anomalies. And then as we detect those alerts and anomalies, we'll investigate and respond to those cyber incidents. We act as first responders during the incidents. We also actively share cyber threat intelligence information. And ultimately, all of this is to help protect the state's CAN-WIN network. In terms of information assurance, you heard me mention the ISOs, and so that's where they fit in the org structure. We help agencies build and mature their information security program. We advise agency leadership on cybersecurity risks and best practices. We assist with compliance and audits. We do conduct information security assessments with the agencies, and we assist with risk identification and appropriate mitigation strategies. And then we act as the liaison between agencies and the broader Kansas Information Security Office. We'll touch a little bit now on cyber collaboration and cyber preparedness. And this is where we perform outreach and education efforts with local governments and entities across the state. This is designed to strengthen IT and cybersecurity resilience across the agencies and our local partners. We conduct tabletop exercises to prepare for real-world cybersecurity incidents. We facilitate after-action reviews and capture those lessons that are learned. And then this is also where we administer the state and local cybersecurity grant program. So you've probably heard us talk a little bit about that in the past. So when we talk about cybersecurity, we generally think of it, how do we protect things? We protect things through security controls. And there's three main types of controls that we do this with. There's the administrative controls, operational controls, and technical controls. And really the point of this slide is to talk about how both agencies are wholly responsible for some of these controls, and then also the CISO, or the security office, is responsible for some of these controls. And ultimately, it's through this partnership and working together that we're able to take the controls, apply them, and help improve the security posture of an agency. Defense in depth. This is really just to remind us that the strategy of cybersecurity is about layers. It's about layered capabilities, and it's about layered controls. And so, you know, historically, if we said we have a firewall, we're secure, that's probably not the case, right? We need something more than just a firewall. We need several more layers. We need to build that robust capability that ultimately drives us to the resilience that we're looking for. And again, just a reminder here, in this defense in depth, at those different layers, there will be different responsibilities for both the agency and the Kansas Information Security Office about who's providing that capability set at which layer. All right. In fiscal year 24, there was a service model change for the Kansas Information Security Office, and that's when we started providing enterprise cybersecurity tools to agencies at no cost. And these tools were, on a periodic basis, we go through and we look across the branch. What are the biggest risks? What are the biggest issues that we're seeing? We use that to drive risk-based decision-making about the tools that we're going to assist and deploy across the agencies. Additionally, based upon audit findings, we use audit findings to help us determine those gaps that we're seeing across the enterprise, and we use that to also prioritize some of these capabilities. And the idea is that these capabilities that we're going to deploy will have the maximum or greatest impact and reduce the most risk across the state. And we have been deploying tools since fiscal year 24, and additionally, we have continued working through deployment of new tools for the branch. Wanted to touch real briefly on some core security services and solutions to give you an idea of some of the things that we've been doing. So we have an enterprise-wide security awareness training platform that we make available to agencies. We have enterprise log aggregation and monitoring. We have our 24/7 Security Operations Center, or SOC. We do endpoint detection and response, or EDR, if you've heard that term. We have endpoint management, where we provide a capability for agencies to be able to patch, provision, and manage their assets. We do firewall engineering and management, network intrusion prevention, incident response support and coordination. We touched on the CAN-WIN network security earlier and some oversight for the security operations across that network. We provide disaster recovery planning and training support through our collaboration division. We are standing up capability for external attack surface monitoring across the branch to understand what does our threat exposure look from the outside looking in, and where those greatest public visibilities for exposure are. And of course, we do information security consulting. And just a quick note here, the services that we just discussed are provided directly to agencies at no cost based upon the appropriation starting in fiscal 24. However, most of these services are only part of the solution to meet the compliance and audit needs that agencies have. So real quick, I want to give an example here about vulnerability management. So each agency right now patches systems differently. They may have different patching processes, and they may have different patching tools. And so when we think about cybersecurity and IT operations, to solve for vulnerability management, it really requires a couple approaches here. One is vulnerability identification, which we provide through a KSO-provided tool. And the second part is actually closing or fixing that vulnerability through patching. And right now, that is an agency or agency IT function. So KSO does not have access to all the agency's systems to install the vulnerability scanner. And so we rely upon assistance from the agencies to do that. And then we have, on this idea of different models, there are some agencies that want to do their own entire scanning process, and then others want us to configure the scanning capability for them. We talked about we don't have access to install the vulnerability scanner software on their devices, and the same is then true for deploying patches to those same systems when we identify those vulnerabilities. That's an agency IT function, and we rely upon their assistance to deploy those patches. Lastly, we have been shifting the branch to an approach where we're moving away from kind of that once and done scanning, like once a month, once a week, to having a software system on the actual device so that it does continuous scanning and real-time reporting for those vulnerabilities. The idea being that we can start to close the gap sooner by identifying the vulnerabilities and bringing that data to the agency more quickly. Additionally, on our enterprise cyber efforts, we have been increasing vulnerability reporting capabilities. And so the transition from monthly scans to real-time reporting is what I was just talking about. I mentioned earlier we're doing ongoing deployment of enterprise endpoint detection and response, or EDR, and right now we have that deployed across about 20,000 endpoints. We continue to roll out enterprise endpoint management solution, and so right now we're seeing about 17,000 endpoints on it. We continue the implementation of what we call privileged access management, or a PAM solution, and this helps secure your admin usernames and passwords. And then we have sustained efforts to improve endpoint visibility and agency-level status reporting. And this is bringing that data to the agency staff so they can see more quickly about what's going on and how they fit in the picture to help us close those gaps. On the topic of the SOC, I just wanted to spend a few moments here. So I got a picture up here showing you as we're building out the SOC. You can see here that we have staff, we have activity going on. It is becoming the centralized hub for instant notification and the associated coordination. And in fiscal year 25, we were given an appropriation to staff the Security Operations Center 24/7. And to give you some sense of, like, from the logging and monitoring perspective, currently we collect and monitor, it varies depending upon what may be going on, but somewhere between 8 and 14 billion with a B logs a month within our enterprise security logging platform. Last piece I wanted to touch on was to give you an insight on our Cyber Collaboration and Preparedness Division. We talked about how we go out and we provide trainings and capabilities, and we educate folks to raise education awareness and resilience. And this is just a snapshot of some of the activities that we have committed and planned for those training events and engagements. So with that, that brings me to the end of the pieces I wanted to prepare you on for the Cybersecurity Office.
Thank you, John. And with that, stand for questions, Mr. Chairman.
Yeah, and I just want to ask, some of this we delve into the part where it's secure information that you don't want to talk about in public. Would it be a better use of our time if we just go into executive session and discuss some of those things so we don't start off into something and we need to stop it? Is everybody good with that?
We can do that, sir.
Okay. And do you have some other information that you're going to present as part of the executive session?
Just know if you had specific questions on the executive session.
Okay. So let's go ahead and do the motion to go into executive session, and we'll start with the specific questions.
Yeah, first I think we need Chris to tell us who can stay in the room.
Yes, thank you. For the OIT's presentation question session, people who can remain in the room are Jeff Maxon, Chief Information Technology Officer, and then LPA staff, myself, Katrin, and Alex.
And then, did we want your Chief Executive Security Officer to stay? Okay.
And how long do we stay in this particular executive session, Chris?
Senator Tyson, how long do you think we ought to plan on?
30.
Huh? Well, we're just going to do this conversation with them. You think 15's enough? I guess we can come back out and go back in if we need to. So 15 minutes.
Okay. All righty. So here's the motion. I move that the open meeting of the Legislative Post-Audit Committee be recessed for a closed executive meeting pursuant to KSA 754319A to discuss matters relating to the security measures that protect the information systems of certain state agencies, including the posture of such agencies, and findings related to the information systems of such agencies by the Office of Information Technology Services in prior audits, with the appropriate individuals pursuant to the justification listed in KSA 754319B 12C, because discussion of such matters in an open meeting would jeopardize such security measures, that the committee resume the open meeting in room 546 south of the State House at 1:49, or make it 1:50 p.m., and record and maintain this motion if adopted as part of the committee's permanent records.
All right, we have a motion. Do we have a second? Second by Senator Petty. All those in favor of the motion signify by saying aye.
Aye.
No. Motion carries. We're in executive session. And then for the purposes of this, Senator Peterson is going to You've heard the motion by Senator Thompson. Is there a second? Second by Senator Petty. Senior moment. All those in favor of the motion signify by saying aye.
Aye.
All those opposed, no. Motion carries. We're in executive session.
Okay, we're back out of executive session here. I think we have next an IT audit for the city of Topeka. And Chris will read the names of those who can remain in the room.
For the IT security audit on the City of Topeka, attendees in the room, Dr. Robert Perez, City Manager, Mr. Avery Moore, Assistant City Manager, Ms. Amanda Stanley, City Attorney, Ms. Patricia Biggs, Deputy Director of IT, and Ms. Randy Stahl, Chief Information Officer. From LPA, myself, Katrin, and Alex.
And how long do we want to go into executive session on this one? $30 minutes? Okay, very good. All righty, I'll make the motion here. I move that the open meeting of the Legislative Post-Audit Committee be recessed for a closed executive meeting pursuant to KSA 754319A to discuss matters relating to the security measures that protect the information systems of the City of Topeka with the appropriate individuals from the Legislative Division of Post-Audit and the City of Topeka pursuant to the justification listed in KSA 754319B12C, because discussion of such matters in an open meeting would jeopardize such security measures, that the committee resume the open meeting in room 546 South of the State House at 2:38 p.m. and to record this motion if adopted as part of the committee's permanent records. And is there a second? Second. We have a second. All those in favor say aye. Aye. We are in executive session. closed executive meeting pursuant to KSA 75-4319A to discuss matters relating to the security measures that protect the information systems of Board of Indigence Defense Services, Department of Education, Osawatomie State Hospital, Larned State Hospital, Kansas State Historical Society, Kansas Bureau of Investigation, Kansas Corporation Commission, and USD 501, all of which have been previously audited by the Legislative Division of Post Audit under the direction of the Legislative Post Audit Committee, with the appropriate individuals from Legislative Post Audit and such agencies pursuant to the justification listed in KSA 75-4319B12C, because discussion of such matters in an open meeting would jeopardize such security measures. That the committee resume the open meeting in room 546 of the State House at 255, and to record and maintain this motion as, if adopted, as part of the committee's permanent records.
You heard the motion by Senator Thompson. Is there a second? Second by Senator Tyson. Is there any discussion? If not, all those in favor of the motion say aye. Aye. All those opposed, no. Motion carries. We're in executive session. All right, we're out of executive session. Would anybody like to take any action as a result of the executive session? Seeing none, we'll move on to the next item on the agenda. Next item on the agenda. Oh, and by the way, I want to thank the entire committee for your work today. I never dreamed we would be at the 2:45 item at only 2:55. So I appreciate everybody's restraint and working through the issues today. So with that, we're on the consent calendar items. Kristen, do you want to explain the consent calendar items?
Yes, thank you, Mr. Chair and members of the committee. So the consent calendar is tab A in your all's committee notebooks if you're following along. And there are just 2 items that are on that agenda. So the first of those is approval of the meeting minutes from your last meeting, which was May 12th. You can see those in attachment A. And then the second item is acceptance of the performance audits that were released today, which is 7 performance audits and 1 IT security audit.
Okay, does anybody have any questions for Kristen? I'll give everybody a few seconds to look through it. And if there's no objection to any of the consent calendar items, we'll consider those to be approved. Do we have to approve? We don't have to approve it now, do we? Okay. All right. Next item on the agenda is a new audit proposal. And Kristen, are you doing that also? Yep.
Yes.
We'll let you go ahead and do that then. Item B.
Okay, thank you. So yes, this is tab B in your notebooks. And just a reminder, this is coming to you all as committee rules require. We did receive a request for an audit proposal from the Education Funding Task Force. And so by committee rule, those proposals come to you at the next regularly scheduled meeting. And so I will walk you through that proposal, and then at the end, what we will be looking for you all to decide is if you want to approve the audit. You'll need to kind of reconsider because you just filled our schedule at the May 12th meeting. We would need you all to either approve this and rescind one of the already approved audits to make space for this. You could choose to simply wait on this and add it to the queue for your next spring meeting, or you can choose not to approve the audit today. So the actual audit proposal you'll see in tab B is attachment A. And it would essentially have us answer 3 questions. So it's looking at bilingual funding and student outcomes. So the first question is, how do school districts spend the funding they receive through the bilingual weighting, and do those expenditures comply with state law? The second question is, what have the academic outcomes been of students who have received ESOL services in the last several years? And the third question is, how does the method Kansas uses to fund ESOL services compare to other methods? So this, we are thinking in full for all 3 questions, would require a team of 3 auditors, about 4 months of time to complete. And then if it's helpful to you all in your discussion and decision-making process, you'll see that in this same tab as attachment B, there's a copy of our audit schedule. And so everything that is filled in black off to the left, those are audits that are completed. The ones that are like a darker shade of blue are ones that we've already started. And then the ones that are shaded in the lightest shade of blue are the ones that you all approved at the spring meeting, but that we have not yet begun. So it would be one of those lighter shaded audits that we would be asking for you all to rescind if you want to make space for this one.
And is Senator Erickson online? I know she had some interest to address the committee on it. Okay. And how many people are on the Special Education Committee? Representative Williams, would you like to speak to this since you're on that committee?
Sure. Thank you, Mr. Chair. I would say that that is an important weighting. I would say that there is enough evidence that the money that we are spending on English language is not bearing the fruit that we'd want it to. So I do think it's important. The caveat I would say is that the formula will not be voted on until 2027. So there's a little bit of time. So I would think we would want to engage in some questions relating to some time. First of all, can we find out again or repeat again, how long would this audit take? 3 to 4 months? Okay, 3 to 4 months. And if that were the case, I do think it's very important. I would absolutely vote in favor of it. I'm not necessarily suggesting we remove one, but if we did do so, I'd want it on the queue right away. Otherwise, anything that we learned from it would be of no value.
One of the things staff told me was we did this in 2020, so I know that that data is pretty old. Do you feel like that's too old to not be usable by the committee?
Yeah, we can use it, but honestly, we look at the state assessment data too, and it's not very good. And so, yes, we do need it again. There are a lot of valuable questions to be answered. It's just timing issue, and I would, that's my concern.
Well, and I guess I do want to say, I'm sorry. I'm going to just keep talking, and I'm going to filibuster you, Senator. You know, probably there's not going to be anything more important that happens in 2 years than, you know, looking at the school funding formula. So I do understand the importance of that you guys have good data to make good decisions. Yeah.
Well, one thing I might ask, I'm looking back at these, and I don't know why my brain can't remember some of them. Like, for example, extracurricular policies, I'm not sure what that was. Maybe if we could explain the ones that some of us are struggling to remember. Extracurricular policies, what was that?
And Senator Thompson, did you want to ask a question real quick while they're...
Well, I just wanted to weigh in. I tend to believe, I mean, I'm looking at most of the audits that are in the queue, and I think they're pretty important audits. The IRB, the TAMP, the SNAP, the Fire Marshal, the KUK state admissions. And since Representative Williams said that a lot of this data is not available till 2027, is that correct?
Well, that's when the finance formulas due.
That's when the finance formula. The only, like you, I think the only thing I see that potentially could be considered is the extracurricular policies, but aside from that, I'm not sure what that one was. Oh.
Yeah, what is the extracurricular one?
Coldplay? No, I'm, no.
Go ahead, Chris. Tell us what extracurricular is. Oh, God.
No.
It was an audit proposal proposed by Senator Erickson, reviewing certain CASA and school district policies related to student participation in extracurricular activities. The question was, do school districts and Kansas State High School Activities Association policies comply with state laws allowing virtual and non-public school students to participate in CASA-regulated activities? And then a second question, what policies do school districts have regarding allowing virtual or non-public students to participate in non-CASA-related activities?
Representative Sawyer.
After hearing that, I think it's more important, just from a timing standpoint, to do the
bilingual
ESL. I mean, we could put that one on. I mean, that one's not going to make a big difference if it waits till next year.
Senator Tyson wants to say something, and then we'll come back.
No, I just have a question for legislative post-audit. I think, I was just curious, since there was a 2020 audit, and research might be able to pull or get some of this data and information, would that help pare down the time, your estimates on the date, on the audit?
Kristen?
So there was some discussion about this at the Education Funding Task Force meeting as well. And I think in terms of this audit proposal, question 3, that would look at other methods for funding ESL. That is something, is my understanding, that KLRD has maybe already pulled some information together for, would have the ability to do. However, that is also the smallest question. So even if that question were removed, it spread out over the course of all the other work and the team members we would have is a very negligible difference. So it ends up being basically the same sized audit anyway.
Thank you, Mr. Chairman. Thought I'd try.
Representative Williams?
Okay, thank you, Mr. Chair. Trying to find an option, a solution for us. So in terms of our limited scope, how are we doing on limited scope? And is there any way to take the activities one and break it into a couple of limited scopes and still meet the same kind of deadlines and
On the activities one, objective 2 could probably be a limited scope. What policies do school districts have? That's just gathering policies. Objective 1, I doubt could be a limited scope, and that is, do school districts and KSHA comply with state laws regarding, so we'd have to look at compliance. So that's not limited scope worthy.
Representative Williams, do you want to respond to that real quick?
Well, the only thing I was going to say, if we're unsure, since they both are initiated from Senator Erickson, I would ask that if we don't have a real clear direction that seems to work, that maybe we table it until our next meeting and then ask Senator Erickson what would her preference be.
Do we start to run into a problem where we need to get some of these started, or what's that create from a workflow issue on you guys' part?
So I would say, I mean, one of the issues we would already have is, again, if you refer to the schedule in attachment B, we currently have state office space or the leasing state buildings, the tax exempt property state mandates, and the USD accounting controls all underway. So the only space that we would have to fit this in, if there's any desire to have this finished sometime for discussion in the 2026 session, would essentially be to bump SNAP and TANF, which we were planning to run sort of overlapped because of the efficiencies gained by working with, they would both involve the same agencies. So if we wait to, not knowing when you all would meet again, if we wait for that meeting to approve that, I think we would already have SNAP and TANF underway as well, which just means it would come later in the schedule. So like we might have, if you all approved this being a 4-month audit, you know, maybe it's ready by the end or summer of 2026. I don't want to guarantee anything, but it would push it out. So it's not going to be during session.
Senator Thompson?
Yeah, are you saying bump SNAP and TANF, or start this new audit after those two?
If you were to approve it today, then that would be an option, is bumping SNAP and TANF. If you wait to approve it, then those would already be started and not an option any longer.
I would tend to think I would kind of follow Representative Williams' thinking is, let's see which is a greater priority to Senator Erickson, because there is room right after TANF, which would be in March. It's during session, so, you know, it may be some new information come up during session that adds to that. That would just be my thought, and keep SNAP and TANF in place.
Well, I actually think that because of some of the things in some of the recent federal legislation, SNAP and TANF could be really important to understand. So, I mean, I definitely am not in favor of bumping SNAP and TANF for this, because my understanding also is Well, you guys are going to work most of next year on this funding formula. Anyway, Senator Tyson.
So thank you, Mr. Chairman. Since it is just the extracurricular, or it could be that one, we could just make it interchangeable as to which priority the chairman thought this committee could decide. And that way you would know whether you were starting the extracurricular activity or you were starting.
Okay.
Representative Williams.
Thank you, Mr. Chair. And with the speed of light of technology, Senator Erickson would prefer bilingual to take precedence. The only thing is I would hope we would keep the other one in a high queue so that I see Chris saying, no, we can't. But I think at least from here, we could say our intent of the committee would to be keep it in a high queue.
Senator Tyson.
Thank you, Mr. Chairman. This is a project scheme, and so you would just be swapping out the extracurricular activity for the bilingual, and then the bilingual or the extracurricular would tag on right after it. So we'd only lose a few months on it.
Kristen.
So if you all voted today to approve this and rescind extracurricular policies, but I guess our process normally would be I would reach out to Senator Erickson and then ask if she wants to essentially re-request it for your all's consideration at the next spring meeting. You don't want to do that?
Representative Williams.
Thank you, Mr. Chair. What I'd like to do is to, I don't think it would be in violation of bylaws. You could certainly tell me that, but I'd like to make a motion because we have her request as a priority that we switch out bilingual with the activities, but activities would soon follow after. So that would move us into our next year, and we would take that in consideration in that you might only get 1 month started, and therefore we would choose fewer audits for 2026 to keep that adjustment going. So I don't want us to rescind it. I want that motion to allow bilingual to take its place and the other one move secondarily, and we adjust accordingly.
We're not going to have a change of membership for next year anyway, so I mean, I don't see any harm in that. If we were changing the makeup of the body, yeah, it's going to be the same people. So, I mean, I don't see that it's an issue. Senator Tyson.
So, Mr. Chairman, as I understand the motion, we're looking at the attachment B. It would be the bilingual, and then on that, where the extracurricular activities are, that would follow. And it wouldn't be out of line because I see a couple of projects that are in the light blue that one follow another. So we're really not impacting.
Yeah, I think just the question is, if we were going to have a change in membership because of an election coming up, it would be a different deal. But we're going to have the same members on this committee, so.
Priorities change, we all know that. There could
That's
be
right.
purposes.
Somebody else could bump this one. Yeah.
Thank you, Mr. Chairman.
Chris.
Just on that chart, the white space turns gray in mid-April, and that's just reflecting the April meeting when you load us up with all new topics. So if extracurricular started before April, that's fine. Like Representative Williams says, that would just eat into the number of topics you could pick next year.
Yeah. We're hurting ourselves if we're hurting anybody.
Well, theoretically, it could start after 10th because there's a bigger space there. Same, yeah.
All right. Is there any other discussion? Okay. Was that enough of a motion that you guys understand what we're doing? We're gonna put bilingual into the extracurricular policy and then start extracurricular at the first gap.
Second.
Okay. The second is by Senator Thompson. Okay. Is there any other discussion? Seeing none, all those in favor of the motion say aye.
Aye.
All those opposed, no. Motion carries. Next item on the agenda is our next meeting date. Who does that, Chris? Yes. Are you the one that does that?
Okay, so if you turn to, I think it's tab C in your notebooks, that's a list of, we knocked out a bunch of material today on the July meeting. Thank you very much, and thank you all for your attention and attendance. Next up, in the September, October timeframe, the audits that would be completed then and available for a meeting, USD accounting controls, leasing office buildings, HPIP, limited scope, and an IT security audit of the Board of Nursing. We also, the committee has to meet, they usually meet September-ish or the very early October to approve our budget, because our budget has to be approved by this committee before it goes to the LCC, who normally meets mid to late October. That's really the only criteria. After that, audits coming due based on the changes you just approved. This is a little bit off, but state mandates, SNAP, tax exempt properties, extracurricular policies, that is now going to be bilingual-ish, and all of the rest slot into place after that. So as far as setting a next meeting date, I heard a lot of members talking about travel and international travel, so that might be a challenge, but the only requirements are the executive committee, so Representative Francis, Senator Thompson, and Senator Petty, you three have to meet to preliminarily approve our budget, and then we need a full committee meeting sometime before early October.
Senator Tyson.
Thank you, Mr. Chairman. I have a request to the committee that we would meet for the HPIP audit before September 18th. The tax committee is meeting, or the 17th. The tax committee is meeting, and I would like that presented to the tax committee also, if we could, the September meeting.
Okay, what date are you guys going to have for your September meeting, do you know?
Meeting the 17th and the 18th.
17th and 18th. What, Representative Williams?
Yes, I am going to be out of town, but I know that the 16th would work. It'd be the day before. I don't know if that's too.
Can you guys have that one done by the 16th, HPIP?
Okay, so yes. Yep. Yes.
Okay, let me look at my calendar now. So the 16th is when we need to do it. I need to be a team player here, right?
HPIP and the low-income housing tax credit, Mr. Chair.
Okay. I can do that, because I got to be there this, so September 16th is what we're going to shoot for our next meeting. Okay? And then we have to meet
Executive committee, yeah.
before then.
Same day, or?
And that can be, I believe that can be a Zoom meeting. That can be a
What?
Zoom meeting.
Yeah, let's do a Zoom meeting.
Yeah.
Okay,
Oh, that's a Zoom?
No.
we'll do that, Zoom.
16th is a full.
Okay.
Yeah.
Okay, all right. So tentatively, the 16th. Pretty hard tentative, okay? Is there anything else for the committee? Any other business? No? Well, again, thanks everybody for your work. Great job. And with that, we're adjourned.